Yes.
May I please, Your Lordship? I beg to mention hearing item number 29.
29.
29. For respondent number 5. But kindly list this matter for after 1 week.
Acha. You are for respondent.
Private respondent.
You are for respondent. You are for petitioner.
Petitioner, Lordship.
Acha.
Lordship, I
You
have
have
no
no-
objection. However, Lordship, this matter will list after 3 weeks instead of 1 week, Lordship.
Acha. Wait. What is that matter about?
Lordship, petitioner is challenging the approval order issued in favor of the private respondent number
Acha.
6.
No compensation for the land. Okay. Mr. Swenson, appearing for respondent number 5, submits that he has some personal difficulty
Yes.
in doing the matter today. The prayer is not objected to by Mr. Swenson, Mr.
What is a mere, Lordship?
What is Amir, appearing for the petitioner, list this matter after 3 weeks, as prayed for by the parties.
Lordship, based in the realm, that may be
Acha.
continued.
Okay. Interim order passed earlier shall continue till the next returnable date.
Obliged.
Deeply obliged, my Lord.
Lord, item number 27 of your Lordship's list, my Lord. On the last date, on the 3rd of June, my Lord, it was mentioned in the order that since it is a voluminous matter, it will be taken as a first item in the hearing list. Yeah, if it is not very difficult, my Lord, may I pray, can it be taken as a first matter in the hearing list, my Lord?
In fact, I'm not very well today, so tomorrow I'm leaving.
I see.
So I'm having ORS also. Like I'll see, let me finish the other matters first. This is item what you're saying, 27?
27, my Lord.
27. Acha. This is for some quashing matter, no?
Crossing matter, my Lord. Matter is bit, it will be very easy for your Lordship, but matter is voluminous. Under the is with voluminous.
Okay.
We are
So how long will you take?
I might take at least more than 1 hour, my Lord. It will be 1.5 hours.
Let me see. Let me see. You be here.
Yeah, I will take it.
Yes.
Your Lordship, I beg to mention item 3 to 20. These are all analogous matter, Lordship.
3 to 22.
20, Lordship. 20.
Yes, 20.
Lordship, I'm mentioning on behalf of my senior Gauhati. He is in this post. So if this matter can come up on Monday.
Actually, your Lordship, with the consent, the matter was fixed. But I've been informed that a medical emergency. His son fell down from staircase, fractured his leg.
My God.
So-
His son fell down from the
Staircase, I think.
from the stairs.
From the stairs, fractured his leg. So I said, okay, so. it can
So
be-
Monday will also be very soon, I think. He'll have to have.
No, he has consented. You can go Monday.
Mr. Swenson for respondent.
Respondent number 5.
Respondent number 5 submits that the conducting counsel or the government advocate,
Yeah, for central, CGC.
CGSC. The learned CGSC is indisposed and has some personal difficulty and has prayed for some time Mr.
TB Jamil.
T.B. Zami does not object to the said prayer. List the matter on Monday,
Monday.
as prayed for by the parties.
Lordship.
Obliged, Lord.
Obliged.
Yes.
For admission, item number 1.
In item number 1, I think, Miss, there is a personal appearance today.
Yes,
Then-
it has been 3 times, Lordship. In fact, 3 times this Honorable Court has directed for personal appearance of the respondent, but
What
it
happened?
seems they don't have,
They have not come.
they,
My ladyship here, the condemned number 3, the Home Commissioner, he has been transferred and the new incumbent has taken charge.
So the new incumbent should have come.
yes, exactly, and this
In
is the
case,
3rd
The new
time.
incumbent has not been yet implemented.
Uh-huh.
No,
The new incumbent is yet to be
Hey, it
implemented.
doesn't
but the
matter. But
old
then see.
incumbent
My-
ought to
my-
have appeared,
My ladyship here,
See, they are directed to appear. Both of them should come actually.
actually.
and then my
That is
ladyship, we are not just sitting over the matter now. The case of the condemned has been forwarded to the PNR for final approval because without the PNR approval. now it's
Okay,
final
okay. What
That
is
is
that
another
for?
thing.
That is another. This is actually for what? Appointment.
Yes, yes.
Appointment order.
Yes, yes.
And
So,
then
it's at
and
the final
see,
stage.
see the last order. Of course, we
Yes,
have
yes,
seen.
My ladyship, I have seen.
So they are called. They are directed to appear personally. Now, this is not the way that court's order should be treated.
It's 5
They should come.
5 years.
Tell them to come even in at 2 o'clock. I'll be here. Because otherwise, it's like flouting the court's order.
One of the
Okay, you are taking steps for appointment. Okay, fine. That we will see as far as the merit. But then they are called. They should come. Tell them to come at 2 o'clock.
Appearing on behalf of Indian Song 1880 Lordship is in bereavement Lordship, so
Who is in bereavement?
Song Lordship. Additional AG.
No, I'm not talking about additional AG. I'm speaking about the respond number 2 and 3 should appear personally. AG is okay. I know he is in bereavement, but then they should come before the court. This is what the direction was. Tell them to come at 2.
My ladyship, if it can be then, not at 2, but if it can be on Monday.
And Monday also you'll make excuses. I know.
No.
This is not the way, no? The court's
I
order.
understand.
Otherwise, who will come to the court? What will happen to this institution?
Exactly, Lordship.
Already it has
And this
gone.
is third
It
time.
has.
3rd time personal appearance has been ordered.
Is it?
but,
When was the last time? I didn't see this.
This is 23/6/2025.
23/6/2025 I've gone
And
through.
prior to that also twice. If Lordship could kindly check up the previous orders.
In default, of course, the previous order was on some condition that the respondents are hereby directed to comply with this order on or before the next date of listing.
Yes.
Okay, in default. So they have not complied, so they had to
They-
appear.
Yes. Before that also there is one order, Lordship.
No, before that only, I'm talking about 19/5/2005 order. 19/5,
Lordship.
May.
This is the 3rd time.
This is one. Then okay, next day the personal appearance will automatically be waived. If again see April order,
Yes.
till the next, the respond number 2 and 3 shall remain present before this court in person on 19/5 to explain as to why they have not complied with the order during the expiry of these 5 years. See, so many times their personal appearance were called for.
This may be the I'll make sure that they appear in the next day.
Make sure,
The more the condemned number 2 has been transferred also, it will be something because these
otherwise necessary action will be taken. We have other ways to make them appear.
Yes, ma'am.
Yes. So today, and what is the only merit of the case? What are you saying? That some permission is taken? What? On the merit of the case for appointment of the petitioner.
Yes, we have forwarded to the PNER, which is the final approval of the, without the approval of the PNER, as per the OIM of 2015 for compassionate appointment, it has to be approved by the PNER. So we are forwarded to the PNER for approval. Once it is approved, we will issue the appointment order. That
In
is the
fact, I think the order was passed in 2020
Exactly.
and then 5 years
No, my lord.
for
My
a
lord,
simple compassionate
there's a
appointment.
subsequent, it was filed in 2022. Thereafter, what happened was 2020.
2020, yes.
My ladyship. Earlier, the list of compassionate appointments were prepared and maintained as per the unit wise. But in view of an addendum of 2019, a centralized list of applicants was
2019,
yes.
before
no,
this case.
No, after the addendum.
Ah.
But during the pendency of this case, a centralized compassionate list was prepared and it was circulated. And in the list, the name of the petitioner was figured as number 60. And then the petitioner has again challenged that unity list in a subsequent petition in WBC 115 of 2023, challenging the unity list as well as the addendum. Now this
Yeah, that I have seen. That I have
yes,
seen.
then this honorable court has set and quashed the unity list, which was prepared subsequently, and held that the addendum has to be prospective, and then directed to prepare a new list. So
And ultimately, I think he was placed at serial number 2.
two, yes, that's why, as per the direction, we have meant to prepare another list where the petitioner was placed at number 2. So again, we have forwarded to the government for appointment since they were at serial number 2. So it was after that also due to some requirements of documents, it was delayed. But we are not just sitting over the matter. That is the whole issue.
No, you have
If we are,
delayed.
if we are to say, what they did is, I was placed at serial number 62 in the
And then
seniority
50,
list.
then 2,
Yes.
right?
What they did was, they included all those who died in the police department more than 30 years back, in order to place me at serial number 62.
But that was set as a question.
Anyway,
But then whatever has happened has gone. Now that on the next date, he'll have to come. That is for sure. And then the thing has to be also complied with by next week. Okay. So, Mr. You are additional. No, I know your name. You're additional AG or no? Acha. You are for the. Acha, you are for the respondent number 2. Okay, Mr. M. N. Longkumar, appearing for respondent number 2, submits that although in view of the order dated 23/6/2025, the respondent number 2 and 3 were directed to remain present physically before the court to explain as to why the directions of this court could not be complied with. The said officers, due to their pre-engagements, it cannot be pre-engagements, but okay. In spite of their efforts to appear before the court, in spite of their best efforts to appear before the court, could not come, and as such has prayed that they may be allowed to appear physically before the court on Monday. He has also placed one communication on the update, not update, a communication on the appointment, or on the issue of appointment of the petitioner on compassionate ground. Full stop. The said communications reflects that the requisite documents with regard to the appointment of the petitioner from the police headquarters has been received by the Joint Secretary to the Government of Nagaland. and that the matter has been placed before the PNAR department for necessary examination. Your Miss
Zajimomi.
Jet Jimomi. Miss Jet Jimomi for the petitioner submits that the process has taken more than the required time and that 5 years, more than 5 years have gone by and the petitioner was not appointed on the compassionate basis as per the direction of the honorable, of this honorable court. Wide order dated? It was dated
Which
the original 14/2/2020, right?
Yes, Lordship. Within 2 months.
And the appointments were directed to be made within 2 months from the date of receipt of the order. From the date of receipt of the order. The counsel, Mr. Longkumar, submits that the department has tried their best to comply with the order and there was no willful and deliberate violation, deliberate disorder, disobedience, deliberate disobedience of the honorable court's order. However, it is noticed that the personal appearance of the said respondent number 2 and 3 were directed 3 times by this court.
On 3/4/25.
That is on 3/4.
25.
Court in person.
Then on 19/5.
Yes, that is on 3/4/25.
Then 19/5/25.
Then 19/5/25.
23/6/25.
And then on 23/6/25.
Yes, Lordship.
However, the said respondents have not appeared before the court for one reason or the other, which are in the consideration of this court are not acceptable. Those 2 earlier orders, 3/4, the direction was not exactly sought for. Just see, direction was issued, scantum, it made clear that fails to comply. Next step, the respondent shall remain present in person to explain as to why they have not complied. Okay, it's there. Despite the expiry of 5 years, however, if the order is complied with before the next date, the personal appearance will automatically be waived. Wide order dated 3/4/25. This court had directed the respondents to remain present before the court on 19/5/2025. However, it was also stated that if by 19/5/2025 the order is complied with, then the respondents may not appear. However, the order has not been complied with and it was obligatory upon the respondent number 2 and 3 to appear on 19/5/2025. On 19/5/2025, this honorable court, this court had again directed the respondents to comply with the comply with the order dated 14/2/2020, and in case the same is not complied with, the respondent number 2 and 3 were again directed to appear personally before the court and fixed the matter on 23/6/2025. It is noticed that the order has not been complied with, and as such, it was again obligatory upon respondent number 2 and 3 to appear on 23/6/2025, on which date they were again directed to appear physically, personally before the court to show cause as to why the directions were not complied with. But today, when the case is listed, the respondent number 2 and 3 have again not appeared as per the directions in regions which are not acceptable to this court. It is as such directed that respondent number 2 and 3 should appear personally before the court on 28, right? Oh, no. What is it? 28? 28 July 2025. And if they can appear on that date, necessary actions will be taken by this court. List the matter on 28/7/2025. On that day, the respondents should explain as to why the appointment of the petitioner on the compassionate grounds was not done. Although the order dated 14/2/2020 directed that the appointment should have been done within 2 months. List this matter on 28 July 2025.
Highly obliged.
For admission, item number 2.
Case diary is here. This is a bail, right?
Yes, Lordship.
Commercial quantity.
Lordship.
Yeah, Mr. Courtmaster is giving something. Yes, I'll go to this after she finishes. This is the case status report. Okay, let me go through the FIR. Okay, you can start.
Yes, may I please, Lordship?
Yes.
Lordship, here the petitioner.
This is again
Son-
a Suomoto FIR.
Yes, Lordship, which is
Okay.
at page 11, Lordship. That is the FIR, Lordship. May I read, Lordship? To the so-and-so subject Suomoto FIR. I have the honor to report that in reference to the NDPS 09/25 dated 10/6/2025, where a team was formed and the operation was led by the SCP West along with the OC Suburban PS and the duty party at Suburban PS. The team proceeded to Kohima in compliance of Section 41 to Clause 2 of the NDPS Act after informing the superior officer. Subsequently, the police team raided the warehouse of the courier agency, namely Delivery. Based on the information that due healthcare from first floor stall so-and-so ordered illegal codeine-based cough syrup.
Achha,
A threat
this
was-
healthcare
Yes, Lordship.
orders for this codeine-based cough syrup, right?
Yes, Lordship.
And what is this delivery?
That is the courier service. That is the yes, Lordship.
Raided
That
the
is the
warehouse of the
Delivery,
courier service.
Lordship.
Okay.
Lordship, a trap was set and about 15:30 hours, two persons, namely Siridam Bishwas alias Rohit, 25 years, and Akash Achumi, that is the present accused person, arrived to collect the illegal cough syrup. They were arrested under Section 42, Clause 1D of the NDPS Act, and 25 cartons of illegal cough syrup containing 3,000 bottles of illegal cotton based cough syrup, 120, that is 120 bottles, 25, that is for 25 cartons, Lordship. So were seized in the presence of the independent witness. The seized were packed and sealed on the spot, Lordship. So after this, Lordship.
So those two boys came to collect the cough syrup.
Yes, it is
from
alleged.
not from the warehouse, from
the warehouse, Lordship.
From the warehouse, based on the information that so and so order illegal
Yes,
pudding cough syrup. Okay.
So
they order it, and it is kept in the warehouse of delivery.
It is the pharma from. It is the pharma which is.
They order.
New
Pharma
Health
orders.
Pharma. Yes, they ordered, and it is the two accused persons who went to collect the. However, Lordship, here the co-accused, Lordship. The main accused is the Rohit, Lordship.
Rohit and Akashe Achumi.
Yes, Lordship. So I'm here for the Akaho Achumi, Lordship.
Akashe
Achumi, Lordship.
Otherwise, name is different. Akaho and Achumi.
Akaho is the father of the accused.
Oh,
person,
acha,
Lordship.
okay. He has moved. Oh, so you are for Akashe Achumi.
Yes,
They
Lordship.
both have arrived to
No, Lordship,
collect.
the very fact is that, Lordship, on that very incident day, Lordship, they are friends and they are from same colony. And so this the man accused called Akasha to accompany him to go out for somewhere. So he has knowledge whatever he was that the allegation is, Lordship.
Acha,
So
that is your part of the
yes,
story.
Lordship. So on that day, and in fact, when these seizures were made, Lordship, he was not even inside the quarry. It was the man accused who was inside the warehouse. He was outside. After the police persons arrested the man accused, only he came to know that those illegal items were seized, Lordship. So he has no knowledge whatever about these allegations, Lordship. And in fact, so this accused approached the trial court below, Lordship, the lower court below, and then the bail was rejected. Though the IO submitted that there is no connection, the present accused has no involvement in this present case. It is also based on the statement of the main accused, Lordship. However, the lower court below has rejected the bail on the ground that the drug abuse and the drug trafficking is affecting the society. That was the ground.
In a general manner.
Yes, Lordship. But however, the law is settled, Lordship, that just that the offence are grievous and serious, it doesn't mean they cannot, just basing on the ground, a bail cannot be rejected. And in fact, Lordship, even the IO has submitted his report stating that the person accused has now connection in this case, Lordship. So,
Acha, charge sheet is not submitted?
no, it's in the investigation station.
Where is the rejection order?
It's at page 28, Lordship. That is the annexation.
Where it is stated that IO has stated that he has no connection?
Lordship, it is the third.
It is in the.
Yes, Married, Lordship.
Okay.
Heard both the counsels. and
Which
also-
para?
That is the fourth para, Lordship. Heard the parties. The Lordship has got it.
Upon consideration. Page?
Page 28, Lordship.
28. Okay. Yes.
Heard both the counsels.
Yeah.
And also peruse the application and materials available on record, and also the status of the investigation submitted by the IO of the case. It is transpired from the court that the accused was arrested and produced before the learned magistrate on 11/6/2025 for allegedly found in possession of the commercial quantity of the contraband items. The learned special PP submitted that the IO of the case have submitted a report declaring that the present accused to be innocent and compliant, producing any material showing the step taken by him during the investigation and merely based on the statement of the main accused in the incident. The report of the IO cannot be relied upon, and on the other hand, the incident case being for recovery of a commercial quantity, the regress of Section 37 NDPS is applicable, Lordship. That is what is stated regarding the IO, the report of the IO, Lordship. And again, the observation part is the third para, Lordship.
Drugs
The
abuse.
second, yes, Lordship. Drug abuse and drugs trafficking is becoming a menace which is affecting the society at large, and it has become a rampant in the state, and for which the law enforcing agencies led by the DGP Nagaland has been and is actively involved in the curbing the same. The principle of criminal jurisprudence is that no innocent should be punished. However, it is also a bounden duty of the IO of the case to ensure that the detailed investigation and conduct that, and therefore submit a final report so as to enable the court to consider the dispense of justice as per the law, Lordship. And here, the court has also held that the Section 37 is a regress section, Lordship. However, in my case, Lordship, the accused person is a victim of circumstance, Lordship, and he has no connection whatever with the present allegation, Lordship, and he is innocent, Lordship.
What do
Given
you
in the
say?
seizure list, Lordship, if I may take your Lordship to the seizure list, that is at page 22, Lordship.
Yes.
Lordship, here, page 22 is the seizure list of the present accused person, Lordship. That is the property that is seized. And in fact, Lordship, my sincere apologies, the page 23, that is the continuation of page 19, Lordship. And 20 is the continuation of page, that should be page 23. There has been some error in our part, my apologies. So here the seizure, Lordship, if my, Lordship may kindly see, there is only a mobile that was seized in his possession, Lordship.
And what do you say? What did you say? Next page to 22 is which? What?
22 should, 23 should be 19, Lordship.
19.
Yes, Lordship. Here there is a seizure list, Lordship. And page, if my Lord may kindly see page 20.
And from the other accused?
Yes. There's a page 23, there's a column for action taken, Lordship.
No, 19 does not reflect a name. What? This
Yes.
Anaho Aye.
Yes, Lordship, that
Anaho-
is the continuation page of page 22.
Ah, yes.
So-
now, who is Anaho Ahe?
Inahoye, that is the father of the witness.
Oh, father of the witness.
Yes, Lordship. So the last eight, the number 8, column 8, Lordship.
Huh.
So this is the action taken here in the present accused person. Nothing has been mentioned here. Just the seizure is only the mobile phone in the page number 22.
But at 8, it is said that these are the property which I think includes, yes, cough syrup and all.
Yes, so that is page 23. That is the main accused seizure list. In fact, Lordship, while making a photocopy of the FIR, we have jumbled up the page numbers. So. Otherwise, this is the page number 23 is the continuation of page number 18. And 19 should be the continuation page of the page 22.
But then I didn't understand this item, this serial number 8,
Yes, Lordship.
where it is said that property category.
Lordship, it's at page 23, Lordship. Item number 8, the main accused. This is for the main accused.
How can you say this is for the main accused?
Because the seizure, if my Lord may kindly see the seizure of the page number 18, Lordship.
18.
Yes, Lordship. Nature of property, Lordship, that is at
Acha, this
serial
is in
number 2,
respect
yes.
of Rohit.
Yes, Lordship.
And nature of property, so and so has been seized from him.
Yes, Lordship.
As far as the
Accused, the co-accused is concerned, it's page 22, Lordship.
yes, page 22.
22,
Here
Lordship.
also same witness, right?
Yes, Lordship, there
In
are some
respect
witness.
of Rohit also same witness
Yes,
was
Lordship.
taken.
Lordship.
And thereafter in serial number 8,
Yes, Lordship.
they writes these 2 kinds of cough syrup.
Lordship.
And then
So in the item, in the page 22, Lordship, the seizure is only the mobile phone and the SIM card, Lordship.
acha, nature of the property.
Yes, Lordship.
Mobile phone and the SIM card.
Lordship. So here, Lordship, the present accused has no
I
connection.
think you
Lordship.
have rightly paginated only. Because page number 23 is okay here. And in the property category, nothing is mentioned.
Lordship, then I think it's in my copy only. Then.
Yeah, this is okay. This is, I don't see any mistake in pagination. It's
Okay,
okay.
Lordship. Yeah. I think then there's an error in my copy.
Then?
Lordship. So, Lordship, here nothing was is from
Yeah.
his position, Lordship. And Lordship, here my ground is that he is wrongly accused in this instant case, Lordship. Just being a mere companion cannot criminate a person, Lordship.
That I can get.
Lordship.
So, what do you say on this? Oh, you have submitted this. What does it say?
Kindly come to the next page, Lordship. Starting from 4th paragraph, Lordship.
During further course of investigation.
Lordship. Lordship,
he requested, this is his statement.
Lordship.
He requested Akashe to accompany him.
Lordship.
He also stated that Akashe had no ideas that the consignments were banned drugs. That statement of Akashe Asumi further confirms that he was just accompanying. The accused person in this instant case, Rohit, admitted to illegal trafficking. Further, Rohit was found, so from the above, it is that Rohit is a trafficker, wherein he had made available so and so. During the raid, Akashe was found accompanying accused to transferred. However, accused Akashe during exam claimed to be innocent, stating he did not know what was the consignment involved could not be ascertained so far. But investigation is still in progress. So, the investigation whether his involvement is there or not.
Is there or not, Lordship? Is still.
So, in case we we hold that he was accompanying and he was not involved, then whether section 37 will come as far as Akashe is concerned. Because, give me NDPS, right? NDPS. Because even the police have said that he was accompanying. They are yet to find out whether he is involved.
Lordship.
So if that is the case, he was just accompanying, then it will not be fair to keep him inside. Not anything, every offence punishable accused of an offence punishable for offences under section 19 or involving commercial quantity shall be released on bail. The requirement is just accused of an offence. Now here, he may not be involved, but he is accused.
He is accused
of the offence.
And my lord, section 21C is very serious in nature because.
So what do you say on this, her merit? Apart from the page that the instruction that you have given, that so far he is not involved.
So far he is not involved. As far as the statement of the accused number 1 also is concerned, what he is saying that he was just accompanying.
But that is his co-accused statement.
That is a statement of accused number 1.
Lordship, in fact, in the similar cases, when the statement of the co-accused can be taken in consideration that the other person is also involved in the same case, Lordship, they are taking into consideration. But when, in my case, Lordship, the co-accused has clearly stated that he is innocent. And now
co-accused statement is a weak piece.
Lordship, that I agree, but during the investigation, when it comes to like NDPS case, Lordship is well aware that the statement of the at the time of the statement of the co-accused are also taken into consideration for the
and what any other materials in the case diary against him?
No.
Except this.
Any independent witnesses?
Independent. There was one witness as far as the petition is concerned.
Yes, I've seen his name.
Lordship.
What does he say? His name is Botohu He Kapo. What does he say? Botohu He Kapo. See his statement once.
Lordship, nothing has been mentioned except page 24. Then circumstances ground for seizures.
Give me his statement. Is it in English?
Nothing has been mentioned.
No, let me see. Is it in English?
Lordship.
Or vernacular?
Lordship,
Acha, give me that statement of Botoho B Kapo.
there is no statement as such.
Oh, he was not examined.
He was not examined.
No, he is arraigned as a witness. His statement will be there. Just see 161. Give me the CD. I can see it myself. Give me the case.
This is the only CD I have.
Achha,
This is the only CD.
Oh, this is the only page.
This is the only page, Lordship. I'm just relying on
But the case diary is not there.
This is the status report, Lordship.
But case diary was called, not the status report.
Lordship. Lordship, they have sent me the status report, Lordship.
But by the earlier order, I have called for the case diary, not status. There is a difference between status report and case diary. So case diary is not here.
Lordship, in that view of the matter, Lordship, let it come next week, Lordship, so that I can produce a case diary.
You should have brought the case diary, not the status report.
Lordship, in fact, I have informed the IO to produce the case diary, Lordship. But he
So
has
no
sent me
way
this-
out, miss, you move it on Monday. Because without seeing the case diary, I have called for, they have brought their status report. I have to see the witness's statement. Right.
Okay.
So do it on Monday then.
Lordship, Lordship.
Okay. So, heard Ms. Swenson for the petitioner and Mr. Jimomi, the public prosecutor. During the hearing of the instant bail application, it has come to the notice that the case diary has not been received, but only a status report was sent, which is kept in the records. Since the case involves a commercial quantity, seizure of. Since the case involves seizure of a commercial quantity, the statements of the witnesses is required to be seen in order to find out as to whether the accused is not guilty of such offense. Call for the case diary again. List the matter on Monday, 28th of July.
Much pleasure.
For admission, item number 21.
May I please, Your Worship? Your Worship,
21. Okay. Yes, there is an IA. You don't want to do it today?
24, 21. May I please?
Oh, you're in a wrong case.
Your Lordship.
21.
No. Earlier I forgot to mention. So I beg to mention hearing item number 24 and 25.
This is not the time to mention 20. Let 24 reach. Okay, we wait for some time. Okay. 21. There is a delay of so many days.
Your Lordship, handsome number of days, Your Lordship.
Yeah, 1,447. And then this is GPF amount, right? So, what happened on the last occasion?
My Lord, the service notice may be deemed complete because we have
Acha.
served through the substitute notice by way of publication in the newspapers. I believe it's
Two,
already filed.
respondent number 1.
Yes, Your Lordship.
And
Maybe the
respondent number
respondent
1 is who?
She is the beneficiary and also the aggrieved person.
There is no appearance.
Yes, but the substitute notice is already complete.
Yeah, but
yes,
then-
my Lord.
No appearance.
It
When
is,
did this substitute notice is complete? 17/7 only.
My Lord.
Let us await for some time.
My Lord.
She might come.
Lordship.
It is not many days from 17/7 only.
My Lord, but at least if she doesn't appear on the next date, then at least a
Then
hearing
it can
will
be considered ex parte.
Yes.
But then since the notice has been served only recently, or when it is published,
Correct, my lord. Correct.
so right. The Mr. Swenson appears Joshua. This is Joshua Shaky for the petitioner, and Mr. I always forget your name.
N. Angami, Your Lordship.
N. Angami. Angami is a known title. N. Angami. Okay. N. Angami, the government advocate.
Senior government advocate for respondent number 2, 3, and 4, my lord.
Oh, senior government advocate for respondent number 2, 3, and 4. In the office note dated 17/7/2025, it is reflected that the affidavit pertaining to substitute notice upon respondent number 1 was filed, and it is on records. Although it is seen that they said, although not required, okay, then you say that although the service is deemed to have been complete, but the respondent number 1 who is the beneficiary in the instant case, has not appeared. Neither any wakalatnama has been filed on her behalf. Since the notice has been taken only recently, this court is of the view that the service upon respondent number 1 may be, no, not service, the appearance, of the view that that respondent number 1 is of the view to await the appearance of respondent number 1, list this matter after 2 weeks. If she doesn't appear, then you can proceed with this.
Yes, Your Lordship.
Obliged, my lord.
Yes.
For admission, item number 22.
Am I audible, Your Ladyship?
Yes, of course. 22.
Your Ladyship, I appear on behalf of the petitioner Abhimanyu Kumar of Messrs. Ma Kalyani Forest Produce Trading Depot today in the present matter,
Yes.
with a prayer for bail. If I may just make a very concise submission, on the 26th of June, he was granted an interim, and we want to make a prayer for an absolute bail today. What is worth mentioning is the prime accused has been granted bail in the matter. And if I may take your attention to the forwarding, which is on page 18 of Annexure B.
Page 18.
That's correct.
This is the forwarding report.
Yes. You
After
will
the,
notice,
after the interim, you went and you had given your statement.
yes, he has complied with the police. On the 5th of July, he appeared with the order he was.
May I please, Lordship, before the matter heard to further, my lord, I've received the status report, and in this status report it says that the petitioner has not appeared.
Acha, the status report says that you have not appeared before.
Yes.
He did make an appearance, if I may please your ladyship, on the 5th of July. He had made an appearance after his interim was granted. It's pertinent to mention here that on his appearance, his statement was not recorded. He was slapped twice. He was asked to come on the 14th of the month. However, it created deep apprehension in him. He was slapped at the police station when he did make an appearance on the 5th. His statement was not recorded. He did make an appearance on the 5th of July. That is
Get
worth.
instruction
Your
on
Lordship,
that.
may I kindly see the status report?
Get instruction on that. This is what offense?
Your Lordship, may I kindly see page number 3, the last paragraph.
Okay, according to the status report, you have not gone. But according to the petitioner's counsel, that he has gone and his statement was not recorded. Now that we are nobody to inquire into this.
Yes.
So get an instruction on what is the actual position, whether he at all went.
If I may please your ladyship, I'm sorry. If you come to the, I wanted to take your attention to the forwarding here, because it's interesting that the prime accused, who is also granted bail, he had mentioned 5 people initially.
Okay.
But in the forwarding, you will notice on page 18, he said in connivance, he specifically mentioned 2 people, that in connivance with 2 people, one being Uday Deka and one being Guneshwar Bhorali. Now, what is interesting, your ladyship, is that Guneshwar Bhorali, in case number AB 1565 of 2025, has been granted bail. This is the same matter. The prime accused.
What is the offense?
If I may make a short submission, this was an offense where the prime accused was.
What is the section? What is the offense? 318.
318.
And 316. What is 318 and what 316? Or BNSS? BNS?
316 of entrustment and misappropriation. The main ingredients being entrustment and misappropriation, Your
And
Ladyship,
16
is of cheating and dishonesty inducing the delivery of property.
Acha, acha. Because I hardly remember these BNS sections. Okay, so here, but then the fact remains you have been given interim. Even if the other person is released on bail is a separate matter.
Yes, ma'am.
But the fact is you have been given interim. Now, according to the conditions, you had to go. You said you went, but then your statement was not recorded. And this is a very serious matter. If he goes and his statement is not recorded, it's a very serious matter. Then he could have again complained it to the SP, whatever. The petitioner could have complained. Of course, he is a accused, he will not have those guts. So, get the instruction why, whether he at all went and his statement was recorded and he was slapped, he said.
Okay.
It has to be taken seriously. This cannot be done. And I used to hear in certain other matters also this is done by police sometimes. So get the instructions on that.
Okay.
Okay.
If I may, Your Lordship, he was asked to appear on the 14th, but due to health reasons, which we have documentary evidence of, which we can provide in the court.
But then
And
he
also-
went on 5th, but then it was not recorded. That is
No,
what you
it
are
was-
alleging.
Correct.
Okay. So, right, we heard Miss, your name please?
I'm Shanil Kalita, Your Ladyship.
Okay. Actually, the audio is not very clear. It's like getting echoed. Okay. Then, Miss So-and-so, you can just send me the name. Is it recorded in the... Okay. So-and-so for the petitioner and Mr. Jimomi. Tipa Foam for the public prosecutor. It is the petitioner was allowed interim bail, interim protection by order
Your
dated.
Ladyship, if I may the interim be continued in that case.
Yeah, interim protection, okay. On 26/6/2025. On the condition that the petitioner shall appear before the IO and give his statement. And in pursuance to the above, give his statement, full stop. The counsel appearing Miss So-and-so for the petitioner states that in pursuant or in compliance with the interim order, the petitioner went to the police station to give his statement on 5th of July 2025. However, she states that the statement of the petitioner was not recorded and he was assaulted by the police officer / investigating officer. And that he was again called on 14th or 15th, you said?
14th, my Ladyship. On the
He was
15th.
again called on 14th of July, on which date it is stated that he had some medical issue and he could not appear. Mr. Tipafom, the public prosecutor, places an instruction before this court wherein it was stated by the investigating officer that the petitioner did not follow the direction of the court and he had not appeared before the investigating officer for giving his statement. The said instruction is kept in records and the operative portion is quoted herein below. On 26 you write this. Okay? I've given X to X, you quote that. It will not be out of context to mention herein that if the allegations made by the petitioner that he went but his statement was not recorded and he was in fact assaulted, is a serious issue that needs to be addressed by this court. As such, this court directs the not directs. As such, this court directs the learned public prosecutor to get instruction on the same as to what happened on 5th of July 2025. He may be he may take instructions as to the fact, as to whether the petitioner in fact came to the police station for giving his statement, or he had not come on that day, as has been stated by the investigating officer. When can you get the instruction?
Tuesday, 29.
Okay. List the matter on 29th, on which the learned PP would get the instructions from the IO. Okay, on 29th we will see.
And the interim may be continued, Your Ladyship.
Till then, the interim order passed by order dated 26/6/2025 may be extended. Yes.
Much obliged.
On 29th.
Deeply obliged.
This has to be seen whether this at all had happened.
Okay.
This is not so small issue. Everyone is innocent till he is convicted.
For hearing, item number 23.
Acha, he made a prayer for upgrading. What is the urgency? You have come from Gauhati.
Actually, this
Yes. Yes.
Lordship, I appear on behalf of Mr. H. Gupta, my lord, for the respondents, Lordship. Lordship,
which matter?
in 23, item number 23, Lordship.
In item number 23.
Lordship, the matter was to be mentioned, but Mr. H. Gupta could not connect the online mode, Lordship. Lordship, as agreed by the petitioner's counsel, Lordship, this matter is paid to be fixed on 5th of August, Lordship. If Lordship allows this prayer, Lordship.
Yes, Mr. Muaz Amir is here. Do you have any objection? He couldn't connect perhaps because of the weather conditions and all. Right. Okay. And I have this Rahul Gupta, who is appearing. Can you hear me?
Lordship, why board we on behalf of Mr. H. Gupta, Lordship?
He is for CGSA.
Yes, Lordship.
Okay, right in 23. Mr. H. Gupta, the learned CGSE, could not appear before this court, could not appear virtually before this court because of the network problem, or what do you say? Because of technical reasons. Yes, thank you. Because of technical reasons, and as such, a prayer is made by Mr. Your
Why
name?
board we are, Lordship? Wild board we are, Lordship.
Y. Bormia.
Lordship.
Yes, what did I say? So, Mr. Y. Bormia has prayed for some time. Mr. Muaz Amir, appearing for the petitioner, did not object to the same. List the matter when?
5th of August, Lordship.
List of matter on 5th of August 2025, as agreed by the parties.
Much obliged.
I'll just see once. 24, 25? You are there for 24? Huh. What happened?
Your Lordship, I'm appearing on behalf of my senior, and since he is presently out of station, I request the matter be listed after a week.
Who is your senior?
Supongwati.
Supongwati Waling. It has been prayed. Mr. Swenson, what is the name?
H. Manung Panyar.
H. Manu, appearing for the petitioner, states that the conducting counsel has some personal difficulty and as such has prayed for some time. Prayer is allowed. List the matter after 2 weeks.
A week.
Huh?
A week.
A week. List the matter after 1 week. On a date to be fixed by the registry. Okay. 24, 25 gone.
For hearing, item number 26.
26? You are again there? Oh, it's the same counsel.
Yes, sir.
Okay, same order will be there. The respondent, you are for.
I'm for respondent number 8 here, my lord. In that case, if the matter can come up after 3 weeks, my lord, my senior, Mr. Ejimomi, will be out of station. So, if
So
it
this
can-
will go for 3 weeks. You are agreeable? Okay, heard Mr. So-and-so and Miss for respondent number 8. And you are for?
Respondent number 7.
7, okay. And a prayer is made by Mr. So-and-so that the conducting counsel, same will follow, has some personal difficulty and has prayed for adjournment, which is not objected to by the counsel appearing for the respondent. List the matter after 3 weeks on a date to be fixed by the registry.
For hearing, item number 27.
Yes. Your matter reached in its own course. Yes, 27.
Hello, this is a petition.
Corporate, this is a big petition. You should start with this is a big
Actually,
petition.
it contains the arbitral award.
Okay.
That
Acha,
is how
acha.
it has become voluminous, my lord.
Uh-huh.
In a nutshell, actually, my lord, what has been sought to be done.
Who is appearing for respondent? Acha.
My senior is on his legs in the other courtroom, but they can start, my lord. He'll be here soon.
And you are for, there seems to be 3 respondents.
Yes, my lord. I'm for respondent number 1 and 2, my lord.
You are for respondent 3, so PP will be there, I think. PP is there?
I think Mr. K. Angami is appearing here.
Oh, he
in
was
this
there
matter.
today? Yes, madam?
Yes. He has some personal difficulty today.
But then he appeared, no? Just.
No. He didn't come.
That is different and
Yes.
Oh, no, I got confused. Acha, he has some personal, so
Yes.
in absence of him, how can you do?
Actually, my lord, on the other day, on the last occasion, the state has expressed their mind actually that they are not very interested in. It's a complaint between private parties, so state might not
State
have.
may be pro forma in this case.
But
They have
then
not even
still-
filed their.
But then they are parties, how do we skip it and pass orders?
That will be difficult.
Or Miss Mary can appear?
Yes.
Okay? Take it. Then you can start.
So, Lordship, this is what is in a nutshell, Lordship.
1 second, I'll just put on. Yeah. Yes?
The basic thrust of the challenge,
You are praying for disposal today?
my lord, if it is not very inconvenient, my lord, I would be highly obliged, my lord, if it is.
Yeah, this is, the prayer is for what?
Quashing, my lord.
Of its quashing of what
the criminal
order?
proceedings in CR case number 10 of 2024, which was under sections 120B, 403, 406, 409, 418 and 420 of
All
the-
cheating.
All cheating, my lord.
Okay.
All cheating. And before I commence my arguments, my lord, may I just draw your lordship's kind attention to order dated 9/12/2024, my lord.
9, ouch, wait. 9/12?
2024.
Mr. Courtmaster, please switch on the fan once. Yes, 9/12/2024.
24, my lord. When
Page
opinion
number?
was expressed by
Acha, you want to submit, yes.
Lordship.
Ah,
Yeah, Lordship may kindly peruse that order, madam.
acha, okay.
9/12/2024.
Page?
Order of the court, my lord.
Oh, order of the court. Okay. 9/12/24.
24. By this order,
There is no 9/12, 39. 9/12. One second. Yes. By Justice Borua.
In second paragraph, my lord, this court has duly gone through the complaint and prima facie is of the opinion that the case is civil in nature.
Acha.
So my entire trust in my argument will be to establish before your lordship that it
No,
is-
the case may be civil in nature,
Yes, lordship.
but criminal ingredients might be there in the FIR.
Yes,
that I
Lord.
will see.
That will be
Otherwise,
accepted.
case is civil.
Yes, Lord.
You will have your.
Certainly, my lord, certainly.
The other party will have recourse to civil court.
Yes,
to,
Lordship, Lordship.
But then let me see whether there are any ingredients.
Ingredients were not. And secondly, my lord, there will be a question of jurisdiction as well, my lord.
Acha.
How does the magistrate in Dimapur take cognizance of a matter which was actually, which happened in Gauhati and again one part of it happened in Banaras? I will take your lordship to each and every documents, my lord.
According to that section 409, or what was the section cause where the case will lie?
Lordship.
That can be, if it is a continuous offence, if it lies in various places, then all the places will have jurisdiction.
Well, but all the accused who have been made in the complaint, they never came to Dimapur at all, my lord.
But something has happened here.
It's only a LLP was registered, my lord. The LLP which is here, my lord, is implemented
What
as
is LLB?
Limited Liability Partnership, my lord.
Acha, acha.
Which is the, my lord, respondent number 2 in my case, my lord.
Acha. Okay.
It's a very typical case, my lord, where a contract was originally floated by the Airport Authority of India for establishment of outlets, actually. The sale shops and all for establishment of those outlets, which they call the Master Concessionaire Agreement. And the petitioner number 4 before your lordship, that is Messrs Hotel Pradeep, was successfully awarded the contract, my lord.
To have shops in the airports.
To have shops in the airport. The original contract was of that, my lord. If your lordship comes to page number 175 for the moment, my lord, of my compilation. This is the letter of award, my lord. It is issued to the petitioner number 4, who has been made an accused in the complaint case. The letter of intent to award, LOI, concession to develop, market, setting up, operating, maintaining and managing the food and beverages outlets as LGBI Airport, Gauhati. And now, my lord, down below, at serial number 2, lordship will find the term of concession of this award will be 7 years, with effect from concession fee commencement date as per term clause 5.3 of the RFP. That means request for proposal. It's a type of a contract document itself. RFP, some terminologies will figure like RFP, RFQ. Those are nomenclatures given to the contract documents itself.
Okay. So he was given the concession for 7 years.
For 7 years, my lord. We are the my client is the original contractor, my lord. Which they call master concessionaire.
Achha. Okay.
Now,
that was to respondent number 4.
4, lordship.
Master
Concessionaire. The petitioner number 4, madam. Petitioner number 4 is the master concessionaire. Now, in the next page, lordship will see there is a concession fee, my lord. Because this I am indicating, I have to establish the transparency in the dealings, my lord. Because there was no intent to cheat or deceive anybody. That is why I am troubling your lordship with all these clauses. The concession fee, my lord, it says that the concessionaire shall, in consideration of the concession agreement granted by the authority, pay to the authority concession fee of rupees 1,43,33,333 per month plus applicable taxes and other payments in accordance with the law. Again, my lord, at clause 4, my lord. Clause 4, there will be a security deposit. To the tune of 11 crores 46,66,664.
Okay. These are all paid.
All paid, my lord. My lord, anybody coming to do this kind of business will never cheat anybody. Huge sum of money is involved with Government of India, Airport Authority of India, my lord. Now, if your lordship comes to page number 179, my lord, the Airport Authority issues another letter of acceptance, which they call the supplementary LOI, whereby certain terms and conditions were revised. More particularly, if your lordship turns to page 180, my lord, the concessionaire shall, in consideration of the, now only that monthly concession fees was enhanced to 1 crore 50 lakhs per month, my lord.
What was the amount earlier?
Earlier it was
143.
143 lakhs. Now it was enhanced by the supplementary LOI to 1 crore 50 lakhs.
7 lakhs were included.
Other conditions were kept intact. And my lord, the security deposit was also enhanced to 12 crores.
Okay.
Now, Lordship, this, after fulfillment of all these terms and conditions of the LOI, normally what follows is signing of the contract. Now, that particular bail contract contained a very relevant clause. Lordship will find it at page 167, my lord. Page 167, my lord. This is the root, my lord.
This is what?
My lord, the root cause of the problem, my lord.
This is 167 is a part of what?
Part of the contract, my lord, main contract.
Okay.
It is the RF, they call it the RFP, I think, the request for proposal.
RFP, request for
RFP.
proposal, okay.
These are all contract documents. If your lordship now comes to page 167, my lord.
Sub-licensing?
Yeah. Has your lordship got 167? My lord, down below, clause 5.9. This is very important. Sub-licensing / assignment. The concessionaire may subcontract or subconcession or assign any of his duties in part.
In part.
In part. So he has a right, there is no percentage fixed, like if you will have to give 20%, 30%, he can retain any part with himself and he can give the other balance portion on subconcession to anybody.
This is between them.
It is between them. Now this is the dispute, madam. This is the root cause which gave rise to the disputes, madam.
So the dispute is between you and a subcontractor?
Subcontractor, actually. That is also very interesting. My lord, the son of the petitioner number 1, he forwarded his son and the complainant, they went into an LLP, registered in Dimapur, which was registered in Dimapur, and they took the work on subcontract, my lord.
Achha, show me those.
So it is as if someone is sitting his own son. If you understand the whole gamut of the, my lord, facts, it will be like someone is cheating his own son, which cannot be, my lord.
Achha, show me those.
My lord, I will come, gradually will come, my lord, one by one. Now, my lord, what has happened? The respondent number 1's father, my lord.
So this is the provision that he can subcontract.
Yes,
Gives,
subcontract.
Then?
So far there is no question of any dishonesty on the part of the petitioner. Now the father,
And that enhanced amount was also paid?
Paid, everything paid. To the airport authority, we have to pay diligently, my lord. What happens now? The father of the respondent number 1, my lord, who is the complainant, the main complainant, he approached the petitioners, my lord.
Complainant is not a party here?
He is not a party here. But the transaction happened in that way that he approached the petitioner and requested for giving some part in subcontract.
Petitioner is the concessionaire.
Petitioner number 4 is the main concessionaire.
Oh, yes.
And petitioner number 1 and 2 are the partners.
1 and 2 are the partners?
One are the Pradeep Narayan Singh and his wife, my lord.
Petitioner number 1 and 2 partners of petitioner,
Petitioner number 4.
Oh.
And petitioner number 3, petitioner number 3 and the respondent number 1 are partners of respondent number 2 in the LLP.
Acha, petitioner number 3
who has been made an accused in the
and respondent number 1 are partners
of respondent number 2, my lord.
Of respondent number 2, okay.
So, my lord, it so happened that the father of the petitioner, the complainant, he approached the petitioners for actually the petitioner number 1 and 4, my lord, who runs the partnership, because his wife is just a partner, my lord. She is a housewife. My lord, and requested for participation in the LLP on subcontract basis.
Participation on?
In this, my lord,
this contract
on subconcession basis.
What is the LLP you said?
The LLP was, my lord, I will come to that, my lord. LLP, I will come to that, my lord.
Okay, father of respondent number 1 wanted a partnership in this
to have
contract.
a partnership in the business, my lord. Now, after, my lord, deliberations, a subconcession agreement was signed, my lord.
Acha.
A sub-concession agreement was signed, and that sub-concession agreement, Lordship will find, it starts from page 211, my lord, 211, my lord. If your Lordship now turns to page 211.
Now, petitioner number 1 and 2 are the partners of petitioner 4. But whether he has given it on subcontract to do the work.
This master concession, which he had got from the AAI, AAI permits him to give some portion of his work on subcontract.
In part.
In part. Now, how that happened, my lord? To take it on subconcession, the father of the complainant, who is the respondent number 1, approached. And when
to get it on subcontract.
To get it on subcontract.
Not
and
being a partner.
They are not partners. Now,
partners are 1 and 2.
1 and 2. But after deliberations, it so decided that petitioner number 1 and 2, the 1 and 2, their son is petitioner number 3.
Oh, petitioner number 1 and 2, son is 3.
3. So he will forward his son as a partner of an LLP. And the father of the complainant offered to forward his daughter, who is the complainant.
Achha.
And both the daughter and the son will form a LLP.
Achha.
And this LLP will take the
LLP means?
Limited liability partnership.
Limited liability partnership. So they will take it on subcontract. To execute part of the contract.
To part of the contract.
Okay.
And this, in fact, this subcontract was also executed on papers, my lord. So
to respondent number 1 and the daughter of.
Yeah, my lord. Respondent number 1, and for easy understanding, my lord, it will be like this: respondent number 1 and the petitioner number 3.
Respondent number 1 is the daughter.
Is the daughter of some.
Daughter of the complainant.
Oh no, of the actually that person has not been made party anywhere. But her father approached originally, but he never took part in physically. He never participated anywhere.
Achha.
So if your lordship now comes to page number 211, my lord, this will make things easy, my lord. This is the sub-concession agreement.
Between petitioner number 3 and the respondent number 1.
No, this is between the petitioner number 4.
Petitioner number 4.
Who is represented. Petitioner number 4, who is represented by the petitioner number 1, and the respondent number 2, who is represented by the respondent number 1.
Achha. Respondent number 2 is who?
That LLP.
And respondent number 2. Okay. No, I'm still confused. I mean, the subcontract.
Lordship.
The father of respondent number 1 approached for subcontract.
Subcontract.
Yes.
But
father did not take part.
Yeah.
Okay. So R1 and P3, PW3.
They joined together and constituted an LLP.
LLP.
That is a different thing also.
Okay.
Now that LLP has been awarded a subcontract.
Yes.
By Hotel Pradeep, who is the respondent number 4.
Respondent number 4.
Yeah.
Yes, same.
Respondent number 4 is Hotel Pradeep.
And
this new LLP is called?
Respondent number 4 or petitioner 4?
Sorry, petitioner number 4.
I have, yes. But I get confused with so many. No, that means R1 and P3. They entered into a limited liability partnership. And they were given subcontract. Yes. This is the subconcession.
There is a subconcession agreement.
This is different.
No, this is by which the subcontract was given.
Hotel between Hotel Pradeep and CSA Sana
Vaibhav Hospitality LLP.
Acha, they were not in names.
They were not in names.
So Hotel Pradeep
was represented by, if your lordship sees the pictures now here, the Hotel Pradeep was represented by the petitioner number 1 before your lordship.
Petitioner number 3.
1.
Oh, 1.
Pradeep Narayan Singh.
Okay. Pradeep Narayan Singh is a partner of 4.
Of 4. Yeah.
Okay. So this was entered by petitioner 1 and?
Petitioner number 1.
And CSA Sana
and it was represented by the complainant, the respondent number 1.
This is between P1 and respondent number 1.
One, signatories. Officially they are signatories, but legally speaking, my lord, actually it was between P4 and respondent number 2.
Ah.
P4 and R2.
R2 is
The LLP.
LLP. Yes. The daughter.
Yeah, daughter and the son constituted an LLP.
And who is respondent number 1?
The daughter, that was daughter herself.
And then again you said 2 is also the daughter?
2 is the LLP.
Or 2 is the LLP
2 is
and
the LLP.
represented by 1?
1.
Okay.
Am I clear now, madam?
Yes. LLP is that Sanna Vaibhav?
Sanna Vaibhav Hospitality.
Okay. Yes. Okay.
Yes. Now, my lord, this agreement is made and executed on this 13th day of December 2018 between Messrs. Hotel Pradeep and CSA Sanna Vaibhav Hospitality LLP at Banaras, Uttar Pradesh. So, this was executed in Uttar Pradesh. Now, my lord, will come to page 214, my lord. 214.
Yes.
If your lordship peruses the third recital from top, my lord, whereas both parties agrees that the RFQ,
that is their contract.
yes,
right?
contract,
Documents.
dated to so and so, RFP so and so, LOI, supplementary LOI, concession agreement collectively will be the mother base primary document that covers the relationship and mutual obligation and responsibilities between the Airport Authority of India and the first party. However, both parties equally agree and accept that this subcontract executed between them must necessarily conform, abide, adhere to the terms contained in the RFQ, RFP, LOI and concession agreement, specific and limited to the scope of operation of the second party. Consequently, both parties agree to likewise treat the RFQ, RFP, LOI and the concession agreement as their mother base and primary documents. So, no suppression here.
They will consider the main thing as the mother, as the...
All the documents which my client had got from the airport authority were brought on record and shared with the opposite party. It would have been another case, it would definitely amount to fraud if my client somehow misrepresents, says that I have a contract from AAI which he actually does not have. Then definitely it might have been fraudulent.
He disclosed everything to the subcontractors.
Lordship. Even more importantly, lordship, if your lordship comes to page, the last page of this subcontract, page 223, my lord.
Wait, disclose before the subcontractor, right?
The subcontractor.
The LLP.
LLP.
Yes. Then?
This subcontract contains all the financial aspects also. How much the subcontractor will pay to the main concessionaire and what will be their royalty component, what will be the monthly fee that will they have to be paid. Everything is envisaged here, my lord. But most importantly, my lord, in 223 of your lordship observes down below,
yes,
down below enclosures, everything were annexed to this subcontraction agreement. Now, it cannot lie on anybody's mouth to say that I was misled, I was misrepresented. It may be a breach of contract. Breach of contract may happen, it's a different plethora altogether. But nothing happens with a criminal intent here, my lord. More particularly, my lord, if your lordship, the free will and consent, the free will and consent itself is ingrained in the agreement itself. If your lordship peruses page 222, or just one page before, my lord. The clause 25, that both parties have entered and executed this agreement voluntarily, willfully and without any coercion or fear.
Okay.
This is a very relevant provision in the contract, my lord. Now what happens, my lord? In between, originally it was for a 7 years term which I have shown your lordship. Even this agreement is also for 7 years term. Whatever my client has, this your lordship will see from the top of the first clause of page 222, the same page, my lord. 222, the B, my lord, that's clause B.
For a term of 7 years.
7 years, my lord. So whatever has come to my client's hand, he has given to the LLP, my lord, that respondent number 2, where his own son is also a constituent.
And whether he has given in part or the entire contract?
Part. Only 72 square meter of the contract was kept. Total allotted space was something like 500 some odd. Out of that, only 72 was retained by him. 72 square meter. The rest was given on subcontract.
They will build up shop and they will cover.
Yes. Even shops were developed by my client as per the subcontract agreement. The LLP paid an amount of rupees 5 crore, and out of this 5 crore, this was utilized for establishing the shops, my lord. Now, what happened, my lord, during the course of business, it turned out, it appeared for the LLP that they were not very much satisfied with the facilities that were provided on the shops, my lord. They tried to raise many demands. And this led to the relationship being, my lord, turning bad. However, the fact remains that
between concessionaire and the LLP.
However, the fact remains that main owner of the space, who is AAI, my lord, airport, they never raised any objection. Whereas AAI received many complaints, which I will take your lordship to those things also, many complaints against the LLP serving inferior quality food items to the passengers.
Complaints by whom?
By passengers.
Customers.
They directly raised complaint to the AAI, and AAI in turn asked us that your subcontractor is not doing properly working.
You are for the contractor.
I am for the main contractor.
Yes, petitioner number 4. And the partners.
And the partners.
Son is also, you are also representing the son.
Lordship, yes. Because son has been made an accused in the complaint case. They are very interesting, my lord. They are somehow trying to build up cause of action as we develop in civil matters, my lord. Like if a part of cause of action happens in we try to put jurisdiction on that court. The same thing is followed here, my lord.
Airport, which airport?
Gauhati airport.
Gauhati.
Now, my lord, what happens? During course of, from the very initial stage, my lord, there was bad relations started developing between the parties. And this led to my lord, issuance of a notice, my lord. A notice by the...
bad relationship between?
The parties, the subcontracting parties.
Subcontractor and the concessionaire.
And the concessionaire, my lord. So, my lord, this led to my lord, issuance of a notice, my lord. Your lordship will find in page 235.
Wait. Which page you said?
Page 235, my lord.
Okay. Yes. This is what?
This is a letter issued by the respondent numbers 1 and 2, my lord.
Concessionaire.
To the sub-concessionaires, my lord. Respondent number 1 and 2 are the
they are the partners.
Sub-concessionaires.
They are the sub-concessionaires.
Sub-concessionaires.
With respondent number 4.
With 4.
So, respondent number 4 had
not respondent, petitioner number 4, my lord. Petitioner number 4 is Hotel
number.
Pradeep, my lord. It is addressed to Messrs. Hotel Pradeep, your lordship will see. Dated.
Wait, petitioner number 4 is...
the main master concessionaire who has got the contract from the airport authority.
No, that is petitioner number 4.
Yes.
No, what respondent number 4?
Respondent number 4 is not here in the respondent number 2, my lord.
Respondent number 2. Yes, then? This is a...
So this is issued to Hotel Pradeep, my lord. By CSA Sana Vaibhav Hospitality LLP, my lord.
This is the LLP.
Which is the LLP.
Okay. Between the agreement was entered between Pradeep and Sana. So Sana gave a letter to this Pradeep. Stating what?
Stating, lordship, immediate termination and withdrawal from the sub-concession agreement dated 13/12/2018 executed between Messrs. Hotel Pradeep and CSA Sana Vaibhav Hospitality LLP, my lord.
Okay.
So
they want to terminate it.
They want to terminate it.
The sub-concession.
There's the sub-concession itself, my lord. And in this notice, my lord, if your lordship peruses their demand, my lord, this is very interesting. If your lordship comes to page 241, my lord.
Yes.
241. lot of allegations have been leveled, and finally was their demand through that notice, that is in page 241, my lord.
Clause?
Clause, my lord, the 16, my lord. In the event the aforesaid amount is not paid.
What is the aforesaid amount?
My lord, the 13 crore which they have demanded in subclause 9, my lord, just on the same page, my lord, on the same page, just above 50, my lord.
Okay. 13 crore, they wanted it back.
Back, my lord.
Why?
My lord, they have raised various claims, my lord.
Between the parties, partners only.
Partners only. Various claims have been raised, my lord. And now they are saying that in the event the aforesaid amount is not paid, return refunded to us within the aforesaid period of 7 days, we shall continue to operate and run the aforesaid outlets over 545 square meters sub-concession to us till such time the aforesaid payment along with further claims that we may raise prefer to tender us without however any payment of the agreed sub-concession fee under the sub-concession agreement dated 13/12/2018. Lordship will see the consequence. A high security zone or for entry and exit of every person permits are required. They are in the picture because of us. They would not have been allowed by the airport authority for remain there by any other way. Because of this sub-concession agreement which I have showed your lordship, they were there. Now what they say, that pay us 13 crores, we will not pay you any sub-concession fee if you do not pay.
They have not told you. She is writing it to Hotel Pradeep.
Yes, petitioner number 4.
Petitioner number 4.
Oh, my lord. My lord will kindly once again come to the area of parties, my lord.
Hotel Pradeep is the concessioner.
Yes, the concessioner.
Acha.
Master concessioner.
And Sana is
She is the lead partner of the LLP.
And along with respondent number petitioner
number 3, my lord.
Yes.
Petitioner number 3 has been made silent. He was made to sign certain documents that he will not take active role. He will
Son
take
of 1 and 2.
He will take the back seat, and the complainant will take the lead role in
the lady.
That lady.
The daughter of.
He is not in the picture, so let us say the respondent number 1. So this respondent number 1, she representing the respondent number 2 issues this letter, says that you pay me 13 crores to Hotel Pradeep, the petitioner number 2, the master concessioner, you pay me 13 crores. If you fail to pay, I am going to be there, I am occupying the space, and I will not pay you any sub-concession fee. Resultantly meaning that I have shown your lordship that 1 crore 50 lakhs per month, that will have to be paid by Hotel Pradeep out of its own pocket without earning any revenue from there. And later now that be, my lord, in a high security area, once you terminate the contract, how can you remain there? How can you remain there? It's a public utility space.
And the prayer is to terminate the agreement.
And terminate. Again, I will go to that particular page, my lord. Lordship will now come to that again.
So what she said, or the LLP said,
LLP says,
is that we shall continue, if you don't pay the amount, then within 7 days, we shall continue to operate and run the outlets over 545 square meters, which was
Subconcession to them.
Right.
To us,
till such time the aforesaid payment along with further claims that we may raise, is tendered to us without, however, any payment of the agreed subconscious fee under the subconcession agreement dated so and so. Okay. So she has demanded this amount from him, and without any connection with the amount that needs to be paid.
No, needs to be paid.
1
crore 50 lakhs.
Yes.
It may equally be understood that post this termination, we shall not further pay or tender the subconcession fee in terms of the subconcession agreement for 545 square meter space under our occupation, possession and operation.
This is, I don't understand this. How can one say this?
Exactly, my lord. Exactly. Now, my lord, story will follow, my lord. It went to arbitration, my lord.
Oh, yeah. There is a dispute and there was a clause of arbitration.
And it went to arbitration. But most interestingly, my lord, which we may be of, my lord, some evidentiary value today, my lord, since this is a documentary evidence. Lordship, if your lordship comes back to page 235 once again.
Yes.
The heading of clause 2, if your lordship peruses, which was their primary allegation, my lord. Fraud, deception, misrepresentation,
And
and unlawful inducement.
you have already disclosed them everything.
We
But
have
then they
disclosed
said
that. But my point is, what I am trying to drive home, if your lordship notices the date of this letter,
18 November.
18 November 2019. So on 18 November 2019, the complainants were very much conscious about the fact, rightly or wrongly, that some deception has been done against them. So what prevented, my question is, what prevented them from filing this complaint at that point of time itself? They waited till 2024. They are wise enough to wait till 2024, and in 2024 they file a complaint in Dimapur, my lord. Had some real fraud been done which were perceivable to them, my lord, they would have gone to the court immediately.
Because the dispute arose, according to you.
Yes, dispute. And it was a purely commercial dispute. They also knew that. They knew that. That is why they invoked, by the same letter, my lord, if your lordship turns, they have invoked the arbitration clause, my lord.
What they are raising is cheating, that we will see.
Cheating, my lord. Now, my lord, we replied to this particular letter, my lord. 243, if your lordship comes to page 243.
So by this letter, they wanted to terminate the agreement.
Terminate the agreement.
Then what do you want to show?
Lordship, actually they have terminated the agreement. It was not even a notice of termination. If I am to understand the contents of the letter correctly, they have terminated on their own, by law, unilaterally they have terminated the contract.
By virtue of contract, they can do it?
No. Because the master concession agreement says, we said in our sub-concession agreement that the relevant for termination, but then I will just take your lordship to that particular clause for a moment, my lord. Once again to that portion of the master sub-concession agreement. What was the provision for termination? Page 222, my lord.
222. This is part of the
sub-concession agreement. The clause, my lord. Page 222, the same clause. This is the only clause dealing with termination, my lord. That it is agreed between the parties that neither of the parties can terminate this agreement before the completion of the term of 7 years. During the lock-in period as agreed and contemplated by both the parties, it is agreed and accepted and approved that neither party would terminate or oust the other party during the lock-in period of 7 years from the date of execution of this agreement, unless agreed otherwise.
Agreed otherwise.
Yes. The parties, if it is agreed otherwise, what will be relevant then? What will be the procedure? The parties will be bound by the relevant clauses of the mother document. Now, what is the mother document? It has been already explained in the sub-concession agreement that those documents which my client had executed with the AAI will be the mother document.
Yes, that you have shown.
Yeah. So, my lord, if you need to terminate, you have to follow the procedure and resist in the mother document. Otherwise, you cannot. Here, what happens?
And in the mother document, yes, of course, they will be bound by those agreements,
yes,
right?
Everybody is bound by those documents. Even
binding will come only to the tune of that in part it can be given in subcontract. What else?
No. Subcontract plus what will be the terms, what will be the mutual terms and conditions
terms
between
of the contract between the concessionaire and the sub-concessionaire are not mentioned in the mother document. It is here.
Sub-concession conditions are here. But it is also agreed in the sub-concession that the terms of the mother document will also prevail. It has not been done away with. Whoever has a consensus at IDEM, that an agreement between the parties, that we will not look into the clauses of the mother document. Then it would have been spelled out clearly. Whereas in 8 places, more than 8 to 10 places in this,
they will be governed by the mother document.
Then they will be governed by the
agreement between the petitioner 4 and the AAI.
AAI. And there is a reason, my lord. These sub-concession agreements requires the approval of the AAI. If any clause is inserted that they will not act according to the main mother documents, AAI will never approve that. Because
this requires approval of the AAI. And AAI has approved.
Yes.
Then?
Now, my lord, what happens? Now, once you say that the space which belongs to the AAI, Lordship, once they say that the space original owner is A, it's a high security area. In a high security area, you will remain there. You have terminated the contract. Once you have terminated, you don't have any legal standing to stay there.
Yes, they are in
You
the
have to move
virtue
out.
of the
You have to move
subcontract.
out. Yes, Lordship. Now what we did, we replied to that letter. That is in page 243, madam.
Reply to the termination.
Reply to termination.
Otherwise, according to the agreement, they cannot terminate.
They cannot terminate.
None of the parties, unless it is agreed between them. And if they...
But here is the situation, my lord. AI wrote to us that we are not bothered what your subcontractor is doing. You are duty bound to carry out the obligations given to you.
Yes, this is
You
what
have to,
it should be. Yes.
This has to be. So, my lord, my clients were actually cornered. You are in possession of a particular space. It is not in my possession. And the access to the space is only through special permits issued by the AAI. So what option is left with my client? So my client applied through this letter, replied through this letter. 243. 12 December 2019.
Yes. Okay.
This is issued to CSA Sana Vaibhav Hospitality LLP. Here, my lord, in the next page, just in the next one paragraph only I will read. What was in the mind of my client, my lord? How he had accepted this, my lord. At the very outset, without prejudice to our legal rights under clause 21B of the agreement and article 19 of the RFQ, that means the mother documents, we accept termination and withdrawal from the subconcession agreement by you, showing your inability to operate the food and beverages outlet, which is meant for public purpose, as the same cannot be stopped for reasons given by you. Therefore, you are directed to hand over the operation of all the food and beverages outlets, enabling Messrs. Hotel Pradeep to successfully operate and facilitate facilities so as no inconvenience is caused to the visitors and passengers at the airport.
So they told them to hand over.
Hand over. And they handed over.
And they handed over.
They handed over.
So they are in a way out.
They are out. Lordship may come to 256 now.
256.
256. Just for showing your lordship, my lord. Through this, that it is a purely business affair that is
This
going
is the part of the reply.
part of the reply, my lord. Through this 256, my lord, my client replied to each and every claims raised by them in writing. We didn't run away from anything. Like that. And then 257, my lord, we raised our counterclaims against them. Because they were in default in payment of monthly concession fee for some time. And that we demanded that from them. They did not pay a single penny against the electricity consumed by them, which we also demanded, my lord. So there are different counterclaims which we had raised. Through this notice, reply notice. And if your lordship now comes to page 261,
This is okay. This is by Sana.
Handing
over, taking over.
Taking over of all food and beverage outlets of 4 square meter space, additional space, and this is signed by both the parties.
Even the son.
Even the son. If your lordship comes to page 262, lordship will notice that it is signed on behalf of CSA Sana Vaibhav, and there is another person signing on behalf of Hotel Pradeep.
Where are the signatures?
There are the box.
Makkan, there are 2. Okay. No, Singh. What is Singh? This Singh? 1 and 2 on the left hand side? In the box?
There are witnesses, my lord.
Oh, these are
Kumar
witnesses.
is the authorized person of Sana, CSA Sana Vaibhav Hospitality.
Who is the authorized person?
My lord, Mr. D. Kumar, some D. Kumar.
Where is D?
He must be the manager.
Yes, D. Kumar.
And here, my lord, it is signed by for and on behalf of Hotel Pradeep Kumar, subject to our attached letter, so along with annexes.
This
is
signed by
their
petitioner?
authorized
1.
representative.
Okay.
So, my lord, this document shows that whatever assets or articles were there, my lord, including the list, my lord, everything were voluntarily handed over by the complainant to the petitioners. Now, my lordship will come to page 355, my lord.
This is also a part of this thing. Handing over.
No, 355 is a different page,
Achha.
different document.
This is 355 is in continuation of what?
355 is the arbitral award.
Acha, I've taken out 255. Okay. 355 is?
The arbitral award.
Matter went to arbitration.
The matter went to arbitration.
And what did the arbitrator say?
My lord, I'll take your lordship. So the issues framed by the arbitrator will be relevant, my lord. 355. This tribunal got constituted pursuant to order dated 22/2/2021 passed by the Honorable Gauhati High Court in arbitration petition number so and so. So, my lord, this is the arbitration award passed by Honorable Retired Justice B.K. Sharma.
Yes.
And if your lordship now comes to page 431, it's a voluminous big award, my lord. If your lordship comes to page 431,
Yes.
Issues, my lord. Because lordship, I'll just take a pause here for a moment. As far as my understanding goes, in some cases, the civil court during trial finds that there has been practical fraud being committed. Some fraud being committed, and it is reflected in the judgment. Then, of course, that may give rise to some criminal culpability. But when the entire issue is on a contractual matrix, my lord, where breach of contract is only involved, there cannot be any question of, my lord, fraud or deception or cheating, my lord. Therefore, the issues with what the tribunal, if it had framed the issues that whether any fraud was committed by the party, the question would have been different, my lord. But the issues that those were framed, my lord, your lordship will see. Issue number C is very relevant. Issue number C may be kindly noted. I am reading all the issues, my lord.
Fundamental breach of, okay.
Fundamental breach of the subconcession agreement. Other issues, my lord, whether subconcession agreement dated 13/12 was validly executed by and between the parties.
This will, okay.
Whether the termination of the subconcession agreement dated 18/11/2019 is legally valid. Which of the parties are in fundamental breach of subconcession agreement dated 13/12/2018. Whether the claimant are entitled to the claims set out in the statement of claim, whether the respondent are entitled to the claims set up in the counterclaim, whether the parties are entitled to interest in respect of their respective claim, what relief depending upon outcome of the above issues, each cost of proceeding. Now, my lord, what happens is a particular portion of the award, a very passing remark was made by the arbitrator, which has formed the genesis of the complaint case. I am taking your lordship to that particular portion, my lord. Page 487.
You have not shown me the complaint.
I'll go to the complaint.
But this arbitral award is after the complaint was filed.
Before.
Oh, before.
Before. Complaint followed thereafter, my lord. I am taking your lordship chronologically, my lord. 487, my lord. If your lordship comes to page number 487.
Part of the award?
Part of the award.
Bapre, this is too big. 487.
487.
Yes. This is the final findings.
One passing observation. I would say, my lord, it is a passing observation by the arbitrator, which has formed the genesis of the, my lord, complaint case. Lordship will find this paragraph.
Acha, which forms genesis? Genesis. I heard which is from the genesis, no, so I thought the complaint is
from the genesis.
Okay.
Paragraph 96, my lord.
97?
97. From the above discussions, on the basis of the materials available on record, including the evidence both oral and documentary, the tribunal is of the opinion that the issue number B and C will have to be answered in favor of the claimant and against the respondent. That means the CS Sana.
In favor of Sana.
Sana. As regards issue number A, having regard to the answers to issue number B and C, it is held that there was some kind of misrepresentation. on part of the respondent in alluring the claimant to enter into the subconcession agreement. This aspect of the matter will have to be considered and answered in reference to the continued breach of the provisions of the subconcession agreement. What is finally established is there is a breach of the agreement. Referred to and discussed about. While it is true that the subconcession agreement dated 13/12/2018 was validly executed by and between the parties, but in view of the continued breach of the same by the respondent from very inception, therefore it will have to be held that the claimant was inducted to the subconcession agreement with deception.
This is where your 420 comes.
Lordship. This is from the
He was-
very basis by.
Yes.
But at what time? That will be very relevant. And how, in what manner? This aspect of the matter will also have to be considered by the subsequent conduct of the respondent in readily agreeing to the proposed termination of the claimant. Here I will pause. It's totally, my lord, in my respectful submission, this award is vitiated, my lord, because it says readily accepted, this type of findings are recorded. Very controversial findings are here. We have challenged this award, my lord. After the Commercial Courts Act has come, my lord, the power of the High Court now has been given to the District Judges Court, my lord, under Section 37 of the Arbitration Act. So first that will be preferred in under Section 34. Now the second one is pending before the learned District Judge Kamrup, my lord, where this award is challenged, my lord. So this is still pending, and we,
You have challenged this award before first whom?
First, before, my lord, actually originally we filed it as per the Arbitration Act. We filed it before the District Judge, the Section 34. Now, once after this Commercial Courts Act was implemented by notification, this jurisdiction was shifted to Civil Judge 1. So, Civil Judge 1.
So your it's pending there.
Yes, Lordship. Civil Judge 1 has rejected our application.
Rejected.
Now we are on again on appeal under Section 37 of the Arbitration and Conciliation Act before the District Judge, and it is pending consideration. On top of it, my lord, on top of it, this award, against this award, they have filed execution case. Execution is also pending. And these two vital facts, Lordship, were suppressed in the complaint petition.
Execution filed after this award. Now execution done.
No, my lord. Now another case. I'll take your lordship gradually. There are many legal questions that will come up now.
Then.
Now, what is in the final award? What was finally awarded by the arbitrator? That is in 502 and 503, my lord. This is the only observation, only paragraph regarding some kind of, my lord, where he expresses an opinion. I will rather not name it as a conclusive finding of the arbitrator.
Opinion, he writes himself, this is of the opinion.
Yes. But finally, what is the award, my lord? Award, lordship, will come to page 502 and 503, my lord. Hmm. 502. In terms of the above, the claimant will be entitled to a total sum of rupees 17 crore 71 lakhs 57,754. And my lord, plus some cost of 30 lakhs and so on, my lord, with interest.
Yes. Okay.
Now,
total amount is those 17 crores, right?
17 crores, my lord. Now, my lord, about the fact of filing, challenging the arbitral award, we have stated in page number 11 of our petition. If your lordship comes to page number 11 of my petition, my lord.
Yes. Paragraph 13.
13, my lord, 13. That being highly aggrieved and dissatisfied with the arbitral award dated 17/10/2022, the petitioner number 4 has filed an application under Section 34 of the Arbitration and Conciliation Act 1996 for setting aside the same. Now, my lord, one step has gone ahead, my lord. Now, civil judge has passed the judgment. Now, that itself is again, that of course we could not narrate since we have filed up.
That you have again challenged between district
before
judge.
district judge. This I can ready to go on record, my lord, of my
Yes.
And regarding the execution, my lord, lordship will peruse para 14, my lord.
District Judge. Paragraph 14.
14.
Paragraph 17 or what?
Paragraph 14.
Your Lordship, at this point, if I may, with due respect to my learned friend, as far as the petitioners are concerned, I have serious misgivings about their bona fides. So if they have indeed filed an appeal under the petition under 37, some documentary evidence.
It can be produced in the website.
Whether that is relevant in the present case. Whether that will be relevant in the present case.
Relevant in the sense, someone who is trying to evade processes. That is the point.
It's listed on 8th of this month. They have appeared, my lord. They have filed their objection. His clients have filed their objections in that case.
That information was not given to me.
I think my learned friend is not instructed, my lord.
I just want. No, that's why I preface my argument by saying, with due respect to my learned friend, I don't have that information.
Your lawyer has fixed it for hearing.
Arbitration appeal number 2 of 2025.
But anyway, at the same time, it has been filed, should have been placed before your Lords.
It can be by way of a subsequent tribunal, but then still I'll see whether that will be relevant.
Now, my lord, regarding the execution, this is very important. This is that in the meantime, the respondent number 2 hearing has the decree.
Paragraph 17.
Paragraph 14. Same page, man. Page 11.
Oh, achha. I went to page 14.
No.
Achha. Okay, yes.
Page 11, paragraph 14. That in the meantime, the respondent number 2 herein as the decree holder has filed an application under section 36 of the Arbitration and Conciliation Act 1996, read with order 21 of the Code of Civil Procedure 1908 for execution enforcement of the arbitral award dated 17/10/2022 before the learned court of the additional district judge number 5 Kamrup Metro, which is registered and numbered as money execution case number 95 of 2023. The said execution application has also been transferred to the commercial court, that is the Court of Civil Justice Senior Division number 3 Kamrup Metro at Gauhati and renumbered as money execution case number 5 of 2024. And the same is pending adjudication before the said court. Additionally, the respondent number 2 filed an application under section 9 of the Arbitration and Conciliation Act 1996 against the petitioner number 4 before the Court of the Additional District Judge number 3 Kamrup Metro at Gauhati, seeking interim protection in respect of the arbitral award, and the said Honorable Court passed an ex parte ad interim award order dated 7/12/2022. So their interests are sufficiently protected by the courts. Directing the petitioner number 4 to maintain status quo with regard to the money deposited by the respondent number 2 as security deposit, subconcession fee and royalty. The said application is pending disposal before the concerned court.
Acha, it will be adjusted with the money given.
Lordship.
Acha.
So there is so far so now this time, my lord, there is no fraud or deception on any of them. Now, Lordship, paragraph 15, if your Lordship reads, these are the pleadings, my lord. That in the aforesaid money execution case, while it was pending before the learned additional district judge number 5, Kamrup Metro at Gauhati, the respondents filed a petition before the court narrating incorrect and false facts. My client has been alleged of doing misrepresentation and many things. My lord, they filed a petition directly saying false facts, my lord, regarding service of notice upon the petitioner number 4, and by misrepresenting had obtained an order dated 18/3/2023 from the executing court, which was shocking to the judicial conscience.
Now, I'm yet to get to the point, like what it is meant. No, first of all, they had lodged an arbitration case, the money execution case. Then it was seeking protection, what? Additionally, go to paragraph number 14. Respondent number 2 means?
My lord,
the decree holder.
The decree holder.
He had filed a money execution. Then what happened?
Under section 9 of the Arbitration Act, my lord, empowers a party to approach the court to seek protection of as interim measures, my lord.
Achha.
As interim measures. And actually
before the decree is finally executed.
Lordship. In fact, actually that section, it does not really explain whether it can be made post award or not.
That is what I'm
So that is how, my lord, they went there Even post-award, they filed this Section 9 application. And rightly or wrongly, court has passed some protective order in their favor. And we are there before the court, my lord, contesting the matter on its merit. my lord.
Achha. And what was that ad interim order? 7/12/22?
7/12/22.
To maintain status quo.
Status quo, my lord. We have annexed that also. We have annexed it. And my lord, again, in the money execution case, my lord, very interesting thing happened, my lord. Because I have to establish their conduct, my lord. They are running after my clients, my lord, like anything. My lord, they have filed a petition. Actually, what happened, Lordship is aware. The issue of summons by the court is only proof of service of notice. If someone writes a personal letter or a personal mail, it cannot be done because our High Court's rules have not been framed in that regard. What they did, my lord, they issued their lawyer issued a personal mail and went to the court and showed that, see, the summons have been served. Court mistakenly issued an order of imprisonment, my lord, for non-appearance. We had to come to the High Court. High Court immediately set that aside, saying that this cannot be done.
Then paragraph 15C?
15, my lord, yes, I'm just reading it. My lord. That in the aforesaid money execution case, while it was pending before the learned additional district judge number 5, Kamrup Metro at Gauhati, the respondents filed a petition before the court narrating incorrect and false facts regarding service of notice upon the petitioner number 4, and by misrepresentation had obtained an order dated 18/3/2023 from the executing court, which was shocking to judicial conscience. By the said order, the executing court was misled to issue a show cause against the judgment debtors as to why the judgment debtors, that is the petitioners number 1 and 2 herein, will not be detained in civil prison till the compliance of the orders for non-compliance or disobedience of the order dated 4/2023. Against this, we went to the High Court. That being agreed, paragraph 16, my lord. That being agreed, the petitioner number 4 preferred a civil revision petition before the Honorable Gauhati High Court under Article 227 of the Constitution of India, inter alia, challenging the legality and validity of the order dated 18/3/2023, passed in Miss J case number 15 of 2023, arising of the money execution arbitration case number 95 of 23, passed by the Court of the Additional District Judge number 5, Kamrup Metro at Gauhati. The Honorable High Court, after hearing both the parties in the matter, was pleased to pass order 21/4/2023, whereby the notice was issued upon the respondent, and in the interim, the impugned order dated 18/3/23 was suspended till returnable date. The respondent number 2 had appeared in the matter by filing caveat, for which the counsel was also heard by the Honorable Gauhati High Court before passing the interim order dated 21/4/2023. The Honorable Gauhati High Court later on was pleased to set aside the order dated 18/3/2023, passed by the Additional District Judge number 5, Kamrup Metro at Gauhati, by order dated 4/6/2024, passed in CRPIO number 109 of 2023.
So that was set aside.
So, my lord, this is the state of affairs, my lord.
Then?
Now, during pendency, Lordship may kindly come to paragraph 17. These are narration of good facts, my lord. Lordship can get hold of the facts from here. That the aforesaid fact of initiating steps by the respondents under section 36 of the Arbitration and Conciliation Act 1996 by filing appropriate petition for execution of the arbitral award, the fact about the fact about passing of arbitrary order dated 18/3/23 by the executing court, an interim order of the Honorable High Court dated 21/4/23, passed in CRPIO number 109 of 23, has been grossly suppressed by the respondents in the complaint petition filed in complaint case number 10 of 2023 before the Chief Judicial Magistrate, Dimapur, Nagaland. Suppression of such relevant and material facts by the respondents established beyond any shadow of doubt that the complaint case number 10 of 2024, currently pending in the Court of Judicial Magistrate First Class, Dimapur, is nothing but an abuse of process of law by the respondents, whereby the respondents, with some ulterior motive, are trying to give criminal flavor to a civil dispute. It is apparent that the criminal complaint filed by the respondents has been made an instrument of spite and vengeance by the respondents against the petitioners herein, since the said respondents failed their ill motive of securing imprisonment of the petitioner number 1 and 2 in money execution case number 95 of 2023, presently renumbered as so and so. The complaint case number 10 of 2024 has been instituted only to cause undue harassments to the petitioners herein and for exerting extrajudicial pressure by giving a color of criminality to an obvious civil dispute and for extract money from the petitioners, which is nothing but a clear case of vengeance. My lord.
We can go to the complaint now. Let me see
Yes,
the
Lord.
complaint.
Yes, Lord. Yes.
Complaint is at?
Page 49, page 49. This is the complaint.
Acha, I have not seen the parties. Pradeep Narayan is petitioner number 1.
He is the petitioner number 1.
Virenu is 2.
Yes.
Vaibhav is 3.
3.
Acha, same.
Yes.
Hotel Pradeep is 4. Okay.
I'll read the complaint now.
It's a long complaint, it seems.
It's a long, but I could not find any criminal ingredient here, my lord. Only reliance lordship will find is again on that particular paragraph 97 of Honorable Justice B.K. Sharma. Lordship will come to page 68 directly, my lord.
Paragraph 97 is quoted.
Is quoted in detail. So I said that is why I submitted this as from the genesis of the complaint, my lord.
Acha, you can read paragraph 29, I think. Sum and substance.
Yes,
of
sum
what
and
has been-
substance. What has been stated herein above lead to irrefutable conclusions as under Messrs. Hotel Pradeep, the accused grossly exaggerated their quotation for the monthly concession fee payable to the Airport Authority of India. I'll pause here for a moment, my lord. Am I not free, being a free citizen, my lord, is he not entitled to quote a amount to the Airport Authority? And the Airport Authority having accepted the tender, where from this type of allegation lie, my lord? They are saying I have exaggerated an amount.
Yeah, you should have then only.
Yes, you should have not come to the subconcession
And
itself.
if subconcession agreement they have agreed.
You should not have signed it.
Then the minimum.
The minimum monthly guarantee mentioned in the RFP was 21,90,000. Messrs. Hotel Pradeep's bid was rupees 1 crore 43 lakhs for 33,333 per month was the highest bid. Is there any mistake in quoting the highest bid?
That's how they were awarded.
This bidding process was in the month of December 2017. The contract to develop, market, set up, operate, maintain, manage food and beverages outlets at Lokopriya Gopinath Bodoloi International Airport, Gauhati was to commence from December 18. Within the period from the award of the contract to the execution of the sub-concession agreement, the grapevine in the food and the catering industry began circulating information about the accused looking for partners to investors. Is it so wrong, madam?
Then the claims.
I deny this statement, but even is it so wrong, even if it is presumed to be correct, that the claims and representations of the accused about their vast experience and expertise, my lord, Hotel Pradeep is currently operating food and beverages outlets not only in Gauhati, in Banaras, in Bagdogra, and since 1992 they are in the business, my lord.
Acha, why the complaint before in this state of Nagaland?
That is more interesting, my lord. Only one recital, my lord. Only one recital in the entire complaint case, my lord. Lordship will come to page 74.
This complaint was lodged before whom? Before the Chief CGM Dimapur. Then?
Dimapur, my lord. Lordship, if your lordship comes to page 74, 30.2.1.
74.
32.1 was, I think, later on inserted, my lord, as an afterthought. Because after 32, 33 is there, then it came 32.1. As a business enterprise registered in the state of Nagaland, the partners of the LLP, that is the complainants and the accused number 3, are amenable to the jurisdiction of the courts in Nagaland. As an SSE in the state of Nagaland, the consequences of the business operations of the LLP take effect in the state of Nagaland. The profits of the LLP, the monies received from the disposal of the properties of the LLP would have been received by the LLP, because nothing has been paid, my lord. My instructions are there. Nothing has been shared out of the LLP till this date, my lord. LLP could not itself run the, my lord, sub-concession agreement, they terminated from where they will earn money, my lord. Now, that is, my lord, is speculative.
But this is the only ground.
Only ground.
For
It is
lodging
allowed
the
for
complaint
seeking
here.
prosecution accords.
For lodging the complaint.
For lodging the Indian.
Because they were continuing
The
their business
LLP was
here.
registered in.
LLP was registered here. They are here. They get the money here.
Lordship. No.
The profits of LLP, the money is received from the disposal of the properties.
Only one business, my lord. Only this LLP was constituted only for the purpose of the sub-concession agreement. My lord. No other business is there. And if that be so, my lord, at least prima facie with the complaint, they should have produced some book of accounts showing that a lot of money is being collected here. Nothing of that sort, my lord. Even the main pinch for them, my lord, is that they are unable to extract the money of the award, my lord. And this award, my lord, my instructions from my client, this will invariably it will reach Supreme Court, my lord.
No, you might get some relief from the district judge. There's plenty.
Not sure. By either side, my lord. They will also go if they do not.
That is all?
My lord, date of complaint.
Yes, date of complaint is what? This one? What is the date?
This, my lord, at least the affidavit.
There is no affidavit with the complaint annexed.
My lord, affidavit is not. But my lord, if your lordship even peruses the year, my lord, 24, they became aware.
What is the date of the complaint? There is no date.
Not here, my lord.
Okay.
They will be having, my lord.
And they will be. Okay. Yes, Mr. Akito, the date you know, the complaint?
Your leadership, I thought the statements of the witnesses were recorded. That was also on file, no? So I did not include the statements of the witnesses recorded in the Section 200.
Section 200 witnesses not there. That will be with the original records, I think. But not
on the same day, the
first order was passed on 21/6.
On that date.
21/6/2024. So most probably this complaint was filed on the
21/6/2024.
2024, my lord. My lord, I have already shown your lordship that notice of termination was in November 2019.
Your leadership, I will give the date later because it was initially filed. Then it was endorsed to another court. The court was not sitting for some time. So the actual
they got the date, I think.
Lordship, I have got the date, my lord, of filing of the first order. If your lordship peruses 504 of my petition, we have annexed it, my lord. Page 504. This is the first order passed.
3/24.
15/3/2020.
Received the complaint, so 15/3.
First order.
15/3 will be the date, I think. Yes. Okay. Then?
So, my lord.
So, criminality only, according to you, is because of that section 97?
97 particular paragraph, my lord.
And you had shown the particular paragraph of the complaint, right? Where the cheating part is mentioned?
Lordship. My lord, there is a police investigation report also, my lord. The learned court below, direct, if your lordship peruses the
directed police to investigate.
Police to investigate. And if that
under 156(3) or something.
If that police report is, my lord, perused, lordship will come to page number 509. We have annexed that also, my lord. 509, my lord. Page number 509. My lord, a very long report is submitted, my lord. But the final finding of the, my lord, the investigation officer, my lord,
is what?
509, page 518, if your lordship.
18, yes.
518, my lord. In the course of investigation, the allegation made by the complainant on Mr. Pradeep Narayan Singh and his family and Messrs. Hotel Pradeep, which shows person entering in criminal conspiracy misappropriation of property of the complainant, criminal breach of trust and causing wrongful loss to the complainant and cheating were mentioned in details. And as per the analysis of the documentations, that means the arbitral award and all, and evidences provided by the complainant and the statements of the complainant indicating that the complainant has faced many losses, and then all the above mentioned allegations made by the complainant against Mr. Pradeep Narayan Singh and family, as they have not yet acknowledged the arbitral award. So this is the difficulty for them. And also no efforts made to return back the amount of the complainant in connection with the instant case. After analyzing the documents and evidence provided by the complainant and the statements of the witnesses, para 97 of the arbitral award, that is why I said, my lord. An award which is still under challenge, which is yet to achieve judicial finality, my lord, has formed the genesis and a passing observation. No issue was specifically framed. Because we can also claim natural justice against that, my lord. Had it been issue been specifically framed in that regard, we would have laid evidence and proved it. That is why it is a simple passing observation of the arbitrator.
Okay, this is the police report.
This is the case, my lord. My lord, do I need to rely these judgments, my lord?
Let me hear Mr. Akito. Okay. Yes.
Leadership, shall we resume at 1?
It's okay, 15 minutes there. Because tomorrow I'm leaving, I have to deliver the judgment, so I just wanted to finish it. Yes. You are for?
I for both 1 and 2.
1 and 2.
1 and 2.
3 is government. 1 and 2. Yes.
1 and 2, yes.
1 and 2 is Sana.
Yes. And 3 is the
and
Sana
Sana
and
representation.
Yes. Sana and the LLP. So, just removing the clutter, going straight to the meat of the matter. Now, Hotel Pradeep, main protagonist. The 1 and 2, husband and wife. 3, son of 1 and 2. They, before that, I filed, so that we can save time, instead of going to a very lengthy discussion as far as the complaint is concerned, I filed a written objection, just to make things easier. And if your lordship, if your leadership will have that written objection.
Is it there on the
Yes,
record?
it is there on the record.
Yes.
Can I start from paragraph 3? Leadership. That the statements in paragraph 4 of the petition are false, misleading, and denied. In the complaint petition, page 49, the answering respondents have narrated the manner in which the petitioners induced the answering respondents to enter into the sub-concession contract. The relevant paragraphs are at paragraphs 8 and 9 of the complaint petition. Page, I have also put the page numbers for easy reference. For the sake of brevity, the facts narrated in the said paragraphs are not reproduced hereunder, and the answering respondents beg the leave of the Honorable Court to be permitted to refer to and rely upon the said paragraphs in the complaint petition. Also, the petitions have mentioned that after several rounds of negotiations and due diligence, a total area of 545 square meters was agreed to be sub-licensed. This statement is misleading. Though the area mentioned is correct, the petitioners actually sub-licensed to the answering respondents an area of only 377 square meters. False statement, Your Leadership. False statement. This is where all the wrong started. Now, Your Leadership, all the facts stated by the opposite side, as far as the business arrangement between the both sides are concerned, that has been elaborately dealt with by the learned arbitrator. The respondents, minus the son, who was supposed to be with me, but who was actively with them. I have enclosed documents in my complete petition to show that the time when he was working with me, he was getting paid by Hotel Pradeep. There was a non-compete clause in the sub-concession agreement, but Hotel Pradeep was running a competing business. When I told my partner, my so-called partner, please handle it, he said, speak to my father. He is not doing anything. They were running a competing business. All those facts are there in my complete petition. And all those facts which have been narrated, they have been dealt with elaborately by the learned arbitrator. They set up as many as 13 counterclaims, which they have been narrating during the course of these arguments. All those counterclaims have been considered and found to be baseless. Can we get back to the petitioner in.
But in the termination agreement, termination letter,
Yes.
they have given this 545 square meter only, I think.
No, wrong, Your Ladyship. No.
Acha.
No.
Mm-hmm.
No.
Huh?
They themselves were admitted in the letter.
No.
Termination, I
There is in
think
their
I've
possession.
seen.
Exactly, my lord. That is
The letter may say that, Your Ladyship. The letter may say that. And the fact of the matter, when I said I wanted to terminate the agreement, they agreed very readily. And
But
they said
that
we
is
will round
stated
up
by
ourselves.
arbitrator also.
Yes, that is said by the arbitrator also. And the formal letter only happened later in that so-called termination letter. Otherwise, you took over the business immediately. You were very happy to take it
No,
over.
in fact, what immediately, I mean, the tussle was going on for some time. There were
Yes.
complaints also, I'm told, to the AAI about the
Yes.
wrong functioning of your client. So perhaps he also wants to terminate and he agreed immediately.
No, Your Ladyship.
Huh.
The point is this. They agreed to the termination immediately. They wanted to run the business. They asked us to hand over all the equipment purchased with our money to them.
And it was handed over.
It was handed over and they signed the receipt for the same. Now, what we are saying is the equipment that we purchased, it was misappropriated by them.
But then you handed over now, how can you say misappropriated?
No, because the sub-concession agreement says that the property which is purchased by me, 5 crores which I invested, 5 crores and all, that belongs to me. That belongs to me. There is a very specific clause. I will not borrow your leadership by taking this there on record. This property, they induced me to hand over. And this property, they misappropriated. En bloc. And what do they say? It became useless, so it's no more there on sale. Only those which are working, we are using. New property, really, 5 crores plus of property, ACs, fittings, chairs, etc., one vehicle also.
Okay.
So they induced me, saying that you will take back the business, you hand over the entire machinery and equipment, fittings, etc., whatever is there, on as a various basis, we'll accept it. They took it. After they took it, they misappropriated it. So it is very wrong for them to say that my complaint is based only on that paragraph 97 observation by the learned arbitrator. Very wrong. Can you go back to the objection, Your Lordship? That the statements in paragraph 7 of the petition are misleading and denied. The outstanding electricity bill, as mentioned as serial number 7 of the counterclaim in tabular form, is a sum of rupees 30 lakhs and odd. And the fee for additional space is mentioned as serial number 5 in the amount of 6 lakhs and odd. However, in this paragraph, the amount mentioned by the petitioners is rupees 34 lakhs and odd. Wishing to make every paise possible at the expense of the answering respondents, the petitioners made the answering respondents pay the electricity charges for an entire area of 545 square meters, when in fact, the answering respondents were using only 377 square meters. Therefore, the payment of excess electricity charges was a point of dispute between the parties. This resulted in the so-called accumulated amounts for electricity usage and additional area charges. In the arbitration proceedings, the petitioners set up a counterclaim for the amounts mentioned in this paragraph. The counterclaim was rejected. The arbitral award is at page 354 to the petition. 6. That the statements in paragraph 8 of the petition are misleading and denied. The relevant page of the arbitral award at page 415 of the petition records counterclaim number 3, the claim of the petitioners against the respondents mentioned in this paragraph. In fact, all the claims in the counterclaim set up by the petitioners were rejected by the arbitral award dated 17/10/2022. The rejection of these claims will be seen in paragraph such and such. In the counterclaim, the petitioners set up as many as 13 claims as reflected in paragraph 22 of the arbitral award. The said claims are mentioned in tabular form at page 423. At serial number 3, the outstanding amount claimed for the sub-concession fees is 5 crores and all. However, in this paragraph, the amount mentioned is 5 crores 52. Even the amounts have changed. 7. That the statements in paragraph 9 of the petition are misleading and denied. The petitioners, by their questionable conduct, forced the answering respondents to issue a notice terminating the sub-concession contract. In fact, as mentioned in the complaint petition, when the answering respondent number 1 indicated her inability to continue with the sub-concession contract, the petition number 3 in the instant petition, the partner of the respondent number 1 and MS Sana, etc., the respondent number 2 herein prevailed upon her to let his father and MS Hotel Pradeep, the petitioner number 1 and the petition number 4 in the instant petition, run the business from the month of September 2019. So even before the formal letter of termination, they persuaded me to let them run with effect from September 2019. The facts in this regard are mentioned in paragraphs 21 to 24 of the complaint petition. With regard to the notice, the amounts mentioned therein relate to the refundable security of 5 crores and odd, the sum of rupees 5 crores for the construction and erection of the outlets, the additional payments of 16 lakhs and odd and 54 lakhs and odd paid by the answering respondents, number 1, to the petitioners for the procurement of furnitures, fixtures, fittings, equipments, etc. in the sub-concession area. In the notice dated 8/11/2019, paragraph 14 mentions the nature of the claims against the petitioner, and the same cannot in any way be termed as exorbitant as alleged in this paragraph. For 2 areas, one measuring 35 square meters, another measuring 38 out of 179. 38 was not given to us. The answering respondents were made to pay monthly sub-concession fees and the development costs without the area actually being provided for their use. For a third area measuring 191 square meters, the answering respondents were made to pay the sub-concession fees for the period January-February 2019, though the petitioners failed to make it operational during these months. Now, what is important here, Your Ladyship, was, in the sub-concession agreement, the petitioners, they promised the respondents a fully functional and operational area. Wrong. They did not provide such an area to us. We had to make further investments. We had to make the area operational. For these areas, the answering respondents demanded appropriate action in terms of refunds as well as the handing over of the same for the use of the sub-concession. The dispute in relation to the non-availability and non-use of these areas is mentioned in paragraphs 110 and 120 of the arbitral award. So this is also reflected in the award of the arbitrator. The statements in paragraph 10 of the petition are false and denied. The petitioners were not forced to accept the termination of the sub-concession agreement. They eagerly and willingly accepted the termination of the sub-concession agreement. In fact, even prior to the termination of the sub-concession agreement, in the month of September 2019, the petitioners had begun running the sub-concession contract area by themselves. By letter dated 8/11/2019, the formal termination was issued to the petition number 4. In their acceptance letter dated 12/12/2019, the answering respondents were directed to hand over the sub-concession area. The acceptance of the notice of the termination is what is relevant in the letters of the petitioners dated 12/12/2019. Through this letter, they demanded that the answering respondents leave the business to them without removing any of the machineries, equipments, etc. in the sub-concession area. The petitioners, including the partner of the answering respondent number 1, gave the assurance, so that is the son, gave the assurance that the sums invested by the answering respondents for making the sub-concession area operational would be repaid, the total sum of rupees 5 crores and the additional amounts subsequently paid. It was on this assurance that the answering respondents submitted to the petitioner a letter dated 28/12/2019. This letter contains an inventory of assets purchased by the answering respondents between 1/4/2018 to 30/11/2019.
You do one thing, you point out the main cheating part where they have.
I'm
you have
coming to
shown.
that. It is mentioned here.
Acha.
It is correct.
You have otherwise shown area is less given.
Yes.
Less area was given. Part of the area was
not operational.
Not operational. Then they did not give fully furnished things. They had to kind of which were all against the agreements.
Yes.
In those parts, what you are saying, you were cheated.
Yes.
And what more areas?
Yes. No, in this paragraph, I make a specific mention of the machineries and equipment which have been handed over not being there. They being removed by the petitioners in 9 truckloads.
After termination?
Yes. After termination. Sub-concession agreement says it belongs to me. They said they will run it, give all the machineries and equipment to them as is various basis. They said they will return the money to me. 5 crores and odd which I invested. They did not return the money to me, they misappropriated the money also.
But whether that was in the agreement, 5 crores they had to return?
No.
In fact, the master concession agreement says otherwise.
No.
If they do not voluntarily remove it, it becomes the property of the AAI. Mutatis mutandis, it will become
that
the
is again a
property
very
of the
wrong statement.
concession.
That is a wrong
I
statement.
take your lordship to those.
The sub-concession agreement says the amount of 5 crores which is spent, which is utilized for machineries, equipment, etc. Right? It will be used for purchase of such machineries and equipment, but that will belong to me.
That will belong to you?
Yes, that will belong to me. Very specific. There is no such clause that it will revert back to the Hotel Pradeep. What they made me do in September 2019, 11 October, December, they made me hand over the entire machineries and equipment to them. They said, nothing in written. This is the unfortunate part of the relationship. Nothing in written. They said, the 5 crores and odd which I invested for this purpose, they will return to me. Now they are saying they don't owe me anything, and they are saying even that property belongs to them. But no, that property belongs to me. And unless they give me the 5 crores and odd, they cannot misappropriate it to themselves.
Then
So they said that they would give it to me. They used me to hand over the property. They did not return the 5 crores and not to me. At the same time, they more or less took off, misappropriated the entire machineries. Maybe some machineries are there, but 9 truckloads they took away from them.
Then
So the assets handed over were received by the petitioners by the letter dated 29/12/2019. Regarding assets handed over, the petitioner number was examination before the question, responding to question 69 to 71 about the custody of the assets. He stated, only equipments in our custody, others were all dismantled because they became scraps. This is his own statement, Your Lordship. When questioned as to whether all other items except the ones dismantled are in his possession, he stated yes. Others in running condition are in my possession. When questioned about whether he has been using and operating them, he said some of them are under my use. These statements of the petitioner, number 1, are deliberate falsehoods, inasmuch as it is in the knowledge of the answering respondents that upon taking over the sub-concession area, the petitioners removed 9 truckloads of fittings, furnitures, fixtures, machineries, stock in hand, etc. So this is my case, Your Lordship. This is my case. They induced me to hand over the property to them, property which belongs to me. They said that they would give me money in return for that. They have not given me the money, and they have misappropriated the property also. Then, of course, paragraph 9, how I was induced to enter into the partnership because they said their son will also help me. Their son also helped me. He is an expert in the food and catering business. He will help me. But he was of no help at all. In fact, he was silently working with his parents. And I have documents, I have enclosed that in my complete petition. He was being paid all along by Hotel Pradeep. And the most important point of all, Your Lordship will notice, he has joined with his parents in filing this case against me. That itself.
LLP is
It's still LLP is between me and him.
Yes, LLP is still valid, or it is?
It is still there.
It has not been dissolved.
It has not been dissolved. It has not been dissolved. But he has joined with his parents in questioning me and the activities of the LLP.
He is an accused, my lord, named as accused in the complaint case. He has to recover.
And as far as the property is concerned, the master concession, the sub-concession concerned, at page 118, just to clarify that point.
180.
280.
280.
Sub-concession area.
Yes.
In the event, as Your Lordship read, the paragraph starting with in the event.
In 218.
218.
80.
18.
Yes. In the event of any termination.
In the event of any termination or expiration of this agreement, either by affix of time or otherwise, all the aforesaid items included and inventorized by way of NCG would devolve and remain in the exclusive share and ownership of the second part. That is the LLP.
Okay.
So paragraph 9 is about how the son came into partnership with me in an effort to convince me, to induce me to take up the partnership, then to take up the business. Then paragraph 10, then paragraph 11 is about the notices and about the statement about the petitioner, the complainant concealing facts about the execution proceeding, about the arbitral petition filed by them. Is it necessary to state all that, Your Lordship? Here we are talking about criminal conduct. How I proceed to recover money on the civil side is a different issue altogether. So can that be taken as a suppression of fact so as to oust me from coming before the Honorable Court or the courts below and filing a complaint against him because of his criminal conduct? Because of his criminal conduct, I think that is very far-reaching argument, Your Lordship. Not necessarily.
No, we will confine ourselves to only criminal liability.
Yes.
And as you have said, the belongings were taken, and agreement was that they will keep it to themselves, but you did not, you had taken it and you did not pay the money back.
Yes.
Where was the agreement that on termination? You have just shown, right? 218. that on termination the the articles will be taken back, but the what?
If your lordship peruses the handing over, taking over note, which their representative has executed under their letterhead.
Where is that? Handing over, taking over? Note?
After termination. Yes, lordship, page 261. Page 61. Lordship will see who writes this letter, my lord. To Hotel Pradeep, which is the petitioner number 4, signed by, addressed to
Yeah,
Pradeep
you had
Narayan
shown
Singh.
all these things were taken.
Yeah, signed by.
But where is the requirement that you have to pay rupees 5 crore?
My lord,
Acha, let him finish
initially there was a clause in the agreement that they will invest 5 crore. That is another difficulty. They will invest 5 crores or on behalf of them we will develop the space. We have developed exactly more than actually 5 crore. It was not even confined to 5 crore. And we shared all the bills and receipts with them. And then when they started raising complaints, we said, see, our liability is only to the extent of 5 crore. If you wish to develop it further, you do it by yourself. And there were letters written by us that you kindly give us pinpoint that for this particular article you are unable to do this, 10 number of customers have walked away from your stall. Give us something like that.
Okay,
Specific letters were there.
Finish.
Okay. Now it's 1 o'clock. We'll resume at 2 then.
Very, very late.
We were at paragraph 10, so
Yes,
we
yes.
will start from here.
Very, very late.
How long will you take?
Maybe another hour.
Make it short
I'll try.
so that I can dictate.
I'll try.
May I please your ladyship?
Yes. What happened?
I'm so sorry. My deepest apologies, first of all. This is regarding item 22 that we had just gone over. There was a slight miscommunication, which I'm deeply regretful about. The date he appeared in front of the police was not the 5th of July, it was the 9th of July. And leaving that on the order will be erroneous. I pray for the correction.
Okay, I'll make it 9th of July.
Thank you so much.
That's all.
Okay, thank you.
Thank you. Thank you.
My lord is
Yes.
well or?
I'm okay. I'll only do this matter. No other matters will be again heard.
Lordship, I beg to mention item number 31.
Not today, huh? 31.
Yes, Lordship.
Okay. Some custody of daughters, right?
Yes, Lordship.
You are there for the petitioner? And you are there for the respondent?
Respondent number 3.
3. Okay. The steno is not there. Okay. Counsel for respondent is taking time. You want
Yes, Lordship.
Miss so-and-so? In item number 31, huh? Miss,
Kitty Engine.
your name is there?
Oh, Ayala Engine, sorry.
Uh-huh.
Ayala Engine.
Okay. So-and-so prays that she may be given some time to conduct the case. The prayer is not objected to by Miss. You are?
Lucino.
Okay. And solo.
No, Lucino.
Lucino. Okay. List the matter after 2 weeks or on a date.
18th of August.
Okay. List the matter on 18th of August.
And there's an interim.
Interim?
date to be extended.
Now, as you know, once we have found out that the interim was extended, but there was no interim at all. So I need not check, right? Okay. Interim order passed earlier shall continue till the next date. This is 31, right? Huh, okay. Yes.
Mr. Lordship, I beg to mention in item 30.
30.
Lordship, I'm appearing on behalf of the petitioner's counsel. The petitioner's counsel is unable to appear as he is in bereavement.
Okay.
If the matter may kindly be listed after a week.
Okay, Miss So-and-so submits that the conducting counsel is in bereavement and has prayed for some adjournment The prayer is allowed. You have informed the other side?
Yes, Your Lordship.
Yes, prayer is allowed. List the matter after a week on a date to be fixed by the registry. I think item number 28 is there, right?
Yes.
28, anybody for item number 28? You intend to do the matter today?
Yes, sir.
But then this will continue and I'm not very well. I'm leaving tomorrow. So do it next week?
Yes, sir.
Okay. List the matter next week as prayed for by the parties.
Obliged, sir.
I hope this is not too much trouble, Your
No,
Ladyship.
no, it's okay. I'll continue. I'll do it.
So, Your Ladyship, first, just so the facts are placed before Your Ladyship.
Yes.
The inventory of the articles which I handed over. Page 261 is the covering letter, and the articles are from page 266 to page 338. Just to note the facts. 266.
These are the items you had handed over.
Yes, 266 to 338. And again, just to place the fact here, actually again, page 216, which is the sub-concessionary agreement. This is insofar as it relates to the 5 crores and the article which I bought. 216. And clause 11 of the sub-concession agreement.
216, you want me to see?
Yes, Your Lordship. It begins from page 21. It starts from clause 11, it starts from page 217. And it is clause 11, Roman 11. So, may I read, Your Lordship? This is important. That both parties agree, accept and approve that the first party, which is Gauhati, will incur an expenditure of composite sum of rupees 5 crores, inclusive of a GST, towards the enactment, operation, and functional utilization of the entire space, comprising of 545 square feet. That is the space which was supposed to be given to me. That the utilization of the entire, that the first party will provide and the second party will accept under this agreement. The second party, upon making the aforesaid payment. So I am supposed, the language is a little funny, but then I am supposed to make a payment, 5 crores. Will be entitled to an unfettered and absolute enjoyment of the said 545 square meter space, and the second party may use and utilize in such manner, mode, and fashion that the second party may determine and decide in accordance with the model documents. That the aforesaid space of 545 square meters will be completely operational in every conceivable manner and form, including all fittings, etc., etc., etc. The second party cannot be asked or demanded to do anything further than the aforesaid composite sum, which shall be a total payment by the second party. Before tendering such payment, the first party will provide a complete inventory of all such fittings, fixtures, equipment, gadgets, kitchen items, etc. for the kind consideration and knowledge of the second party. It is also agreed between the parties that the first party will provide all available requisite bills and memos and invoices witnessing such expenditure for the records of the second party. In other words, the aforesaid amount that the second party will pay and tender the first party would undoubtedly include all the aforesaid facilities that would be necessary for enjoying and rendering functioning the units space provided by the first party to the second party. Since the construction, erection, etc. of this agreement, it is agreed that post signing of this agreement, all further expenditure towards making all the food and beverage outlets completely operational will be exclusively by the first party. That it is also agreed, accepted and approved that on payment of the aforesaid total composite consideration of rupees 5 crores, the second party would become the absolute and complete owner in exclusion of the first party of all the aforesaid gadgets, kitchen items, fittings, fixtures, furniture, crockery, cutlery, and other items, including warranties, guarantees, AMC contract, etc. In the event of any termination or expiration of this agreement, either by a fix of time or otherwise, all the aforesaid items included and inventorized by way of Annexure G would devolve and remain in the exclusive share and ownership of the second party. No confusion now, Your Ladyship. It was my property. They induced me to hand it over. I handed it over to them. They have misappropriated.
But the property were yours.
The property was mine.
But 5 crores was given by them.
By me.
Or by
By
you?
me.
Acha, acha.
Yes, that is why it belongs to me.
Yes,
That is why
yes.
it belongs to me.
Sana had given.
Yes. Now, then, Your Ladyship, just to not take too much more of your time, page 49 is my complete petition. Page 49.
Page 49.
Yes, is my complete petition.
Of the
the
complaint
paper.
petition?
Yes.
Which is annexed with the petition?
Yes, yes, it is. At
Page 49.
Page 49. And
Yes.
And earlier, Your Ladyship was referring to one particular paragraph. Page 21.
Page 21?
Page 21.
2-1?
Yes, 21. Page 69. Sorry, Your Ladyship, the board number.
Yes.
I was looking at the small print.
69 of the
Page 69.
complaint.
Of the paper book, which is my complaint. Yes. So, the brief facts.
That we have gone through.
Yes. So just placing it again for your Ladyship's consideration. Then, the modus operandi which I say that the indulgent, at paragraph 30, page 71.
Yes.
Then, your Ladyship, you kindly turn to page 25. We just want particular paragraph. Page 73. 73, Roman 6.
73.
Yes.
Roman 6.
Roman 6.
Okay.
Though a partner in MS, CSA, LLP, etc., the accused number 3 continued working with MS Ujjwal Pradeep and his parents. The accused number 1 and 2. So that was the conspiracy. That was the conspiracy. Then, my little friend has drawn your Ladyship's attention to 32.1 at page 74. But your Ladyship will look at paragraph 32. May I read, your Ladyship? That the LLP is a registered entity having its registered office at Dimapur, Nagaland. As a business enterprise registered in the state of Nagaland, the LLP files its income tax returns in the state of Nagaland. The complainant number 1 as an SSC is an SSC in the state of Nagaland, files her ITR in the state of Nagaland. Her ITRs are in relation to all her businesses, including the business of the LLP. Now, the ITR returns as far as the LLP is concerned, page 340.
But whether that would be a ground for filing a complaint here?
I'll come to that.
Achha.
I'll come to that.
340?
Yes, 340. 340. And your Ladyship, you see, income is 0. Because nothing came to me. We were running at a loss right from the very first instance.
This was for the year?
1920.
1920.
Then next is 2021. 21, 22. 22, 23. Then page 344 onwards are her personal ITRs of the Sana, Miss Sanchana.
No, page 344 is in respect of
Miss
Sanchana only?
Yeah, in her personal capacity. Her ITRs.
Not as an LLP.
Not as an LLP.
This is as an LLP.
Yes, as an LLP. Yes. So, settled principles of law, Your Ladyship. The complaint must disclose a prima facie case. Prima facie case.
Prima facie case, prima facie cognizable
Yes.
case.
Yes. Prima facie cognizable case. Yes. And at this stage, is there any need to look at evidence? There is no need to look at any evidence. Just two principles. Just two principles. Now, Your Ladyship, I am writing a certain authorities. I have culled out the principles. I am not placing the entire books. The first one is 2012, 3 SSC, 132, paragraphs 28, 38. The principles, Your Ladyship. In offences relating to criminal misappropriation or criminal breach of trust, the court within whose local jurisdiction the whole or part of the consideration were required to be returned or accounted for would have jurisdiction in the matter. Where what a party has been deprived of by an act of cheating can be claimed through a civil action The same deprivation based on denial by way of deception emerging from an act of cheating will also attract criminal liability. So this is about a civil liability. From a civil liability, it can also be a criminal liability. Just because it has tinges of civil liability doesn't mean that a criminal liability doesn't lie. So, and the principle is where it is accounted for, where the property was sought to be accounted, where the property is to be accounted for.
That court will have jurisdiction.
That court will have jurisdiction. That court will have jurisdiction. I filed my ITRs in the MOPU. The profits and losses of MS Sana LLP will be accounted for in the MOPU. So therefore, the courts of the MOPU have jurisdiction.
This court, this decision says, right?
Yes, this decision says.
2012. Otherwise, 409 or 109, the place of jurisdiction, ordinary place of.
Where the offence occurred.
And if it falls in so many places,
any of the
then
other places.
any of.
Even in this case, it has not been explained how he falls in on that.
What he is saying that he receives everything here, the money will be accounted for here, whether that will be a.
Accused number 2 is the wife who never been here. Wife of 14 man. How do you bring it?
No, that's fine. So the profits and losses of the LLP will be accounted for here.
Okay, let him finish.
Who is responsible? Who is responsible? They may not be from here. There's a distinction here, Your Ladyship. Who is responsible? That person may not be resident within the jurisdiction of the courts at Dimapur. But if any cause that they have done results in consequences for me here, then the court here has jurisdiction. That is the principle which I'm relying on.
Okay, I'll go into 2012 3 SSC.
Then 2, this is Vihar Chakrabarti. The allegation relating to criminal breach of trust can be inquired into within the jurisdiction of the court within whose local jurisdiction the offence was committed, or any part of the property which is the subject of the offence was received or retained or was required to be returned or accounted for by the accused person. It was supposed to be accounted here, Your Leadership. Then paragraph 3, 2021-14 SCC. A civil remedy being available is not a ground for quashing criminal proceedings if a criminal offence has been made out.
Yes.
Then 23, at the stage of issuing process to the accused, the magistrate is not required to record detailed reasons. There should be adequate evidence on record to set the criminal proceedings into motion. Now, Your Leadership, in my case, apart from what I have said in my complaint petition, if Your Leadership will kindly see what I have annexed to my complaint petition as documents. This is at page 75.
Here.
Yes. Page 75.
Yes. Yes, documents.
Page 75. Yes. So, list of documents, certificate of incorporation, LLP, partnership agreement, then relevant extract from the RFP, letter of intent, supplementary letter of intent, relevant extracts from emails, sub-concession agreement, received by MS Hotel Pradeep, then invoice, then balance sheet of MS Hotel Pradeep. So these documents, this balance sheet is to show that payment was made to the son all the while that he was working with me. Balance sheet notice, then at page 77, the letter by which he accepted the termination, then handing over of the sub-concession area, then acknowledging taking the the acknowledgement of taking over possession, and ITRs that I have filed.
Yes.
Then, yes, ITRs. So these are the documents which I have filed along with my complaint. Now, there are 3 cases which I have further relied upon. These are not reported, but I have the copies. The first is
Mohan.
2024 Supreme Court 233.
Grounds for invoking 482.
Yes, yes. Grounds for invoking section 482. This is 2024.
Of course, only in exceptional cases those facts. Only
Yes.
on exceptional cases where.
Okay, and then the next one. This is about jurisdiction. Now, this is writ petition number 19725 of 2020. This is an interesting document.
First one also you give that Mohan versus State.
Yes, Mohan versus State.
I'll have to refer to it. Mohan versus State is those paragraphs, right?
Yes,
9,
yes,
10, 11,
yes.
okay, for invoking.
Yes.
That I will see.
Yes, and this one is Radhika versus the Principal Secretary, Home Department, etc.
Yes. Here.
Here, it doesn't
Jurisdiction.
have paragraph number as such. It's a short judgment. But can you come to paragraph page 13? At the bottom of the page.
This is by which court?
This is by the Telangana High Court here.
Telangana High Court.
Yes, Telangana High Court. The seal is embossed within the page.
Oh yes. Telangana High Court.
By a division bench of the Telangana High Court.
Page 13.
Page 13. Yes. Therefore, even if a part of the offence had occurred in Mumbai, even then,
Wait, I don't get it. Oh yeah, last part.
Yes, the last
part. Even if a part of offences occurred in Mumbai.
Even then, as part of the offence had occurred in Hyderabad, the courts in Hyderabad would have jurisdiction into Hyderabad.
No, this is akin to 109.
Yes, but it goes on further about where it is to be returned.
Okay.
Then the reliance on that authority, then next paragraph, the same logic would be applicable in the present case. For the fraudulent representation was made to the complainant in Hyderabad, the money had to be returned to the complainant in Hyderabad. The money had to be accounted for to the complainant in Hyderabad. Therefore, the court at Hyderabad would have jurisdiction to try the case. On that point only. So all profits and losses would have to be returned at Dimapur. This is one issue. Then another one is, this is again by the Supreme Court. This is about the elements of cheating and criminal breach of trust. What is required to
That
be
is
established.
criminal appeal.
Yes. It's a short judgment, Your Ladyship. So just about criminal trust. So therefore, Your Ladyship, it is my case. It is my case that there is a prima facie case as far as the complaint petition is concerned. The ground taken for opposing my petition is that civil remedy, civil action. Therefore, criminal complaint doesn't lie. Second, jurisdiction. That all transactions happen in Gauhati. Therefore, the court at Dimapur doesn't have jurisdiction. The law is very clear, Your Ladyship. Prima facie case, civil, it may have tinges of some civil liability, but that does not preclude the filing of a criminal case. Thirdly, as far as jurisdiction is concerned, partnership registered here in Dimapur, income tax returns filed here in Dimapur, the profits and losses of the LLP would have been returned here in Dimapur, therefore the courts have jurisdiction. That is my case.
Okay. Any reply? Short reply, okay.
My Lord, I beg your Lordship's pardon, my Lord. We have not brought a document on record just for your perusal, my Lord. But you may take it or may not take it up. No, this is a letter issued by the Airport Authority of India when they came to know about this termination of the sub-concession agreement. Because in my humble understanding, my Lord, breach of contract is a different thing. The criminal breach of trust, someone will have to have criminality behind his mind. Why I am placing this document before your Lordship now? Because the allegation is made that I have retained the assets, which I have already shown those were voluntarily handed. I will again take your Lordship to that reading of the document. Documents
I've seen those are okay.
Lordship. Now, what was my obligation under the main contract? What this petitioner before your Lordship would have, what other option would have was available after getting this instruction from the AAI, my Lord?
What is this?
This is written to the Hotel Pradeep, my Lord. Termination of sub-concession agreement dated 13/12/2018 between Hotel Pradeep and CSS Sanaba LLP for operation and management of food and beverage also and so. Subject compliance to be done by master concessionaire. That is the direction of commerce. The information by letter dated 13/12/2019 received on 16/12/2019 on the above subject, the matter have been taken on record by this office. In this connection, you are hereby directed to operate all the F&B outlets allotted as per license agreement executed between AI and SS Hotel Pradeep without hampering any passenger facilities. Further, you are advised to continue your man/material as per AI security norms, and if any withdrawal addition takes place, same may be brought to the notice of the undersigned. You need to ensure that the facilities should not get hampered at any cost, at least it's a passenger facility as well as ASQ rating 2. My Lord.
They wants to be things operative.
Things operative. Now, Lordship will come to page 261. The handing over, taking over,
Page 68.
261.
261. That you have already shown.
Yes, Lordship.
Yes. Huh.
Lordship, here are two aspects, my lord. First of all, an argument has been sought to be developed that we had handed over them only 377 square feet, my lord, square meter. There is no other evidence to that effect. Now, their own document, this is their own letter, my lord. The document speaks for itself. Lordship will see, very first paragraph. Please refer to your reply dated 12/12/2019, email to us in the evening of 13/12/2019, wherein you have demanded an handover and operation of the food and beverage outlets within 545 square meter. And if your Lordship sees the
Under
sum total,
our occupation.
and through this letter, next second paragraph, my lord, this is very important. Through this letter, we are hereby handing over all the food beverage outlets under the 545 square meter space that was handed over to us as per the above mentioned sub-concession agreement. What remains here? I am repeatedly submitting, my lord, this genesis of this entire complaint is that observation of Justice Vacation in that arbitral award, which we are challenging, my lord. It's a very atrocious award. I leave it
That
to,
will be a part of the complaint,
that
but
is, yes, Lordship. That is the very basis. Now, my lord, and the final paragraph, what was their intent in the mind? Was there any criminality anywhere between the parties? Because we never imagined about any criminal case. Hence, we hereby hand over all the outlets, the last paragraph. Hence, we hand over all the outlets with all the equipment, gadgets, furniture, fixture, computers, screens, delivery vehicles, etc. for public interest at large in as is, where is basis. Now, how can you turn around and say that we have induced you? We have induced you, you were cheated, you have voluntarily come forward and handed over all the equipments to Hotel Pradeep without prejudice to our claims against Hotel Pradeep for our above mentioned properties. That means they have acknowledged civil claims. It is pertinent to mention here that we are handing over all the outlets intact with equipment, gadgets, kitchenware, etc. so that the food and beverages outlets are in operational state and the passengers of the Gauhati airport have options to food and beverage outlets at the airport. So, my lord, in my respectful submission, first of all, my learned friend has shown that there was a shortage of space. In fact, we handed over, that was a criminality, he is trying to say, which is not the fact. The document says their own document. And there's a consistency in the statement, my lord. If your lordship comes to as I have already shown your lordship, I have already shown to your lordship the termination letter, my lord. At page 235, the relevant portion, lordship will come to page 241. 241, once again, I would like to go. Lordship will see the consistency, my lord.
Yes.
241, paragraph 16, down below, I'm not reading it again, my lord. Just, it may equally be understood that post this termination, we shall not further pay or tender the subconcession fee in terms of subconcession agreement for 445 square meter space under our occupation, possession and operation. So where does it come from? That is why, my lord, that is why, of course, that particular letter is not in this criminal case. We specifically wrote to them, kindly pinpoint one of the lacunas on our part, so as that you have to send back 10, 15 customers because of our default. None of such letter came in. Because there is nothing, it is always a subjective satisfaction of all stall owners. Some stall owner may say that I need 5 racks. Someone will say, no, I need the rack in this pattern. That dispute will always be there, but does it attain any criminality? And my lord, in my respectful submission, that handing over, taking over, having been voluntarily done, that cannot attain any criminality to that, my lord. Secondly, my lord, jurisdiction. I again say, my lord, entire handing over of the assets was done in Gauhati. Payments were made in Gauhati. Just because the LLP has filed income tax returns here, will not give the jurisdiction to try a criminal case here. There is no cause of action has arisen. Nothing has.
What do you say on this Telangana's case?
My lord, Telangana, my lord, that may be of persuasive value, my lord, it will not be binding on
That is there, High Court, but
my
then.
lord, it has gone to the Supreme Court like that.
Is it?
We have to check whether any appeal has been filed.
Okay, I'll check that also.
My lord, we don't. Now, my lord, I would like to just place few judgments, my lord. Just very shortly, I will take your lordship to the provisions. My lord, recently, Honorable Apex Court has passed an order regarding this type of cases, my lord. And I am straight away reading from page 4, paragraph 10. Honorable Supreme Court has strongly depicted the action of, my lord, sustainability of this type of criminal cases, my lord. How many times the high courts are to be reminded that to constitute an offence of cheating, there has to be something more than prima facie on record. My learned friend says prima facie, it has to be more than prima facie. On record.
And cheating, you need to have the prior intention, right?
Intention, lordship.
Where did that prior intention exist?
Yes, Your Ladyship. First of all, I was induced into the partnership. Secondly, I was induced into handing over my property to them.
No, simply inducing
Yes.
word will not be sufficient.
Yes.
In order to show that you were induced.
Yes.
What is there in the
Your
complaint?
Ladyship, now that is the subject matter of evidence. Because I am saying, they told me that you hand over all the properties.
That is the second thing,
Yes.
right? Inducing to enter into that subcontract, it is written in the complaint.
Yes. I have said that, Your Ladyship. I have said that.
Okay.
I have said that. I have said that, Your Ladyship. Paragraph, page 56. Page 56. Beginning from page, paragraph 9.3 onwards. In fact, beginning from page 55, paragraph 9 onwards. Carries on, Your Lordship. Then paragraph 10, 10, 11, 12, 13, 14, 15. Your Lordship will see, they were supposed to give me a fully operational area.
Furtherance of the criminal.
Yes.
Those ingredients are there.
Yes.
It's okay.
My lord.
I'll examine, yes. How many times the high courts?
My lord, when it comes to, just as a reply to whatever my lord, lordship has already did not turn the page, I am just indicating that lordship need notice. Saying mere statement will not do. What does the document say? The document speaks for itself, my lord. The very sub-concession agreement, it says that both the parties have entered and executed this agreement voluntarily, willfully and without any coercion of. This entire argument of cheating, deception is an afterthought because they could not successfully run the outlets. There were complaints. They are going here and there. They are trying to impute blame on every action of the petitioners, my lord. This cannot be allowed. Some bigger criminality has to be attributed. Otherwise, everybody will run away from doing business in this country, my lord. My lord, I'm going back to the judgment. How many times the high courts are to be reminded that to constitute an offence of cheating, there has to be something more than prima facie on record to indicate that the intention of the accused was to cheat the complainant right from the inception. The plain reading of the FIR does not disclose any element of criminality. Then, my lord, that particular day race course judgment has been discussed. I am skipping that part. My lord, paragraph 12. Why the High Court was not able to understand that the entire dispute between the parties is of a civil nature. We also inquired with the learned counsel appearing for the respondent number 4 whether his client has filed any civil suit or he has initiated any other proceeding for recovery of the money. It appears that no civil suit has been filed for recovery of money till this date. But in our case, there has been arbitration proceeding. Award is in their favor. Money cannot be recovered more particularly in civil dispute between the parties by filing the first information report and seeking help of the police. This amounts to abuse of process of law. Same as here. We would have said many things, but we refrain from observing anything further. If the respondent number 4 has to recover a particular amount, he may file a civil suit or seek any other appropriate remedy available to him in law. he cannot be permitted to take recourse to criminal proceedings. And it was kind of interfered. My lord, the Sagar Suri's judgment lordship is already aware. See Sagar Suri. I'll just take your lordship to one paragraph. Paragraph 8. Paragraph 8, page number 643, my lord. Paragraph 8. The jurisdiction under section 482 of the code has to be exercised with great care. Now, of course, the relevant provision of BNSS. In exercise of its jurisdiction, the High Court is not to examine the matter superficially. It is to be seen if the matter, which is essentially of a civil nature, has been given a cloak of criminal offense. Criminal proceedings are not a shortcut of other remedies available in law. Before issuing process, a criminal court has to exercise a great deal of caution. For the accused, it is a serious matter. It's a harassment for that lady, my lord, Renu Singh. She will be here, dragged here to Dimapur. She will have to take bail. All this harassment unnecessary she will face. This court has laid certain principles on the basis of which the High Court is to exercise its jurisdiction under section 482 of the code. Jurisdiction under this section has to be exercised to prevent abuse of the process of any court or otherwise to secure the ends of justice. This is one matter. Second lordship will be Vinod Kumar lordship. I'll read only paragraph 11. Right? Referring to the growing referring to the growing tendency in the business circles to convert purely civil disputes into criminal cases, in para 13 and 14 of Indian Oil Corporation case, it was held as under, it is upholding under the law, my lord, para 13. While on this issue, it is necessary to take notice of a growing tendency in the business circles to convert purely civil disputes into criminal cases. This is obviously on account of a prevalent impression that the civil law remedies are time-consuming and do not adequately protect the interest of the lenders or the creditors. Such a tendency is seen in several family disputes also, leading to irretrievable breakdown of marriages families. There is also an impression that if a person would somehow be entangled in a criminal prosecution, there is likelihood of immediate settlement. Any effort to settle civil disputes and claims which do not involve any criminal offense by applying pressure for criminal prosecution should be deprecated and discouraged.
This is okay. On civil and criminal side, it's okay, and you need not give more judgments on that. This is a subtle position.
Yes, and now our High Court. In Kohima bench itself, my lord, Justice Kaushik Goswami, my lord, while sitting in this court itself, my lord, has rendered where he has quashed the criminal process. And in that case also, arbitration was there. If your lordship comes, he discussed with everything, all the ingredients of cheating and all. In this case, which he had dealt, my lord, there was an arbitration clause, and he has taken due note of that. If your lordship comes to paragraph 25, my lord. These are his findings, my lord. Paragraph 25, page 18. It is apparent from the above cases that when the allegation essentially involves civil offense, the same should not be allowed to become a subject matter of criminal proceeding. In the present case, as stated above, it is apparent that the case involves essentially a dispute of civil nature, and therefore it appears that the complainants, by lodging complaint, have resorted to shortcut for execution of non-existent decree, and hence is an abuse of process of the court process, merely because the accused petitioner, having breached 5 numbers of MOUs, in that case many breaches were there, does not make the state breach criminal unless and until the same is done with fraudulent intention from the beginning. Apparent that no such intention has been by the complainants against the accused petitioner. In fact, the accused petitioner has returned the same portion of deposit with the equivalent complaint. Here, my lord. Finally, my lord, this has been set aside, my lord, in this judgment. Also.
Yes, I've seen. It's allowed.
My lord, last one, my lord, the last one. Para 17. This is also 2023 decision, my lord. Last paragraph, my lord. Second last paragraph, paragraph 17, my lord. In the aforesaid circumstances, coupled with the fact that in respect of the issue involved, which is of civil nature, the respondent had already approached the jurisdictional civil court by instituting a civil suit, in our case, the arbitration, and it is pending. There can be no doubt with respect to the fact that the attempt on the part of the respondent is to use the criminal proceeding as a weapon of harassment against the appellants. The indisputable facts that the respondent has filed a pending title suit in the year 2015, he has got no case that he obtained an interim relief against the removal of the office of the secretary and so, my lord. Therefore, my lord, I indicated an order passed by Justice Devasis Borua, where he also examined, while admitting this case, he has prima facie held that yes, it's a case of civil nature. And finally, recently, Justice Arun Dev Sodori has laid down the judgment, my lord. I don't have other, I'm just giving the here also, here in fact, one agreement was found to be not properly done in accordance with law. Even then he said that no, this will be of civil consequence. Criminality cannot be appealed.
Which paragraph? 25.3 GLT? Mark, huh?
The last part.
Kripanath Malla, right? No, Amita Hazoika. Yes, okay. Okay. Paragraph 16 and Roman 2 also.
So I, my lord, finally respectfully submit, my lord, this is a complaint case instituted only because they were frustrated with the objections that have been raised by the petitioner in the execution proceedings. They are unable to execute the award properly in accordance with law. That is why out of vengeance and spite this has been done, my lord. Otherwise, they were all aware about these facts from the very beginning. They could have filed a complaint long ago. If not, at the in 2019, my learned friends said there was the advent of COVID. Then after passing of the award, my lord, in 22 the award was passed. What would tell them for another 2 more years, my lord?
Yes, late filing of the FIR, the complaint, as well as the other things that I have seen. Prima facie, of course, when I will dictate, I will look into deeply. I find it's a kind of a civil nature. Of course, complaint, I'll look into each and every line.
Yes, yes.
If we can show some criminal.
Yes, Your Lordship.
That, as you have pointed out, those inducement and all those not giving them the money, misappropriating.
Yes, Your Lordship. Now, Your Lordship, the point is this. What I am suffering is a continuing wrong. Affairs have not concluded between the parties. It is a continuing wrong. Till today, it is a continuing wrong. It is not as if the transaction occurred 3-4 years ago and then the parties completely lost relationship with each other. They have not. It is still a continuing wrong. It is in that backdrop, Your Lordship. Now, even the issue of inducement is at 2 levels. First is at a time of entering into the concessionary agreement. Second is at a time when they induced me to hand over all my properties to them. And the fraudulent intent, Your Lordship may kindly see that in paragraph 18 of my complaint petition, at page 62. The fraudulent intent. Of course, they are in other paragraphs also, but insofar as the father, son, Hotel Pradeep, and the mother are concerned, paragraph 18, kindly see paragraph 18 at page 62. Can I read? May I read, Your Lordship?
Yes.
That the complainant, number 1, knew the accused, number 3, Vaibhav Kumar Singh is the son of the accused, number 1 and 2. The offer to him included in the LLP was taken. The effort to have him included in the LLP was taken as an act of good faith. However, from the very inception, it became apparent that whilst working as a partner in LLP with the complaint number 1, he was actively employed by MS Hotel Pradeep, contrary to the obligations under the sub-concessionaire agreement. In the 72 square meters retained by MS Hotel Pradeep, the accused in the security whole area on the ground floor, they ran a competing business. The area had electricity backup and they ran a food and beverage outlet selling the same and or similar food items. That too, in the case of most items at cheaper prices. They were even undercutting me. The complainant number one's partner, the accused number 3, did not object and or question MS Hotel Pradeep, his parents, the accused 1 and 2. He was content to let them run a competing business vis-a-vis the LLP from the balance sheet of MS Hotel Pradeep from 2016 to 2020. It is evident that even during the subsistence of the contract, the accused number 3 was highly paid employee of MS Hotel. And paragraph 20, that the request of the complainant number 1 to the accused to fulfill their obligation under the sub-concession agreement was ignored. The complainant number 1's partner in NBC, Vaibhav Kumar, saying was least helpful. He chose to silently observe what was happening in NDPS business and he would tell the complainant number 1 to take up issues, if any, with his father, the accused number 1. As stated earlier, all along, he was a highly paid employee of MS Hotel Pradeep. His engagement in MS Hotel Pradeep continued even during the subsistence of the sub-concession agreement. To the best of the complainant's knowledge, his engagement was with MS Hotel Pradeep still continues.
And there is no bar. He can assist his father.
In isolation,
but then, yes.
In isolation, yes. But you run a competing business.
He can have a mini business with his father, but as far as this is concerned,
yes.
Okay. He should be loyal and
he should be loyal.
But then, okay, I'll consider this.
Just one last one. The LLP agreement is also on record from page 79 onwards. I could not find a single clause which directly prohibits Vaibhav Singh, the accused number 3, from participating in his father's.
No, this is what it is. There is nothing. Only as far as this contract is concerned, he should be with the
lordship.
Otherwise, he is free
He is a free citizen of the country, madam. Article 19(1)(g) will be.
Okay, since I'm not very well, so I'll not dictate it now. I'll dictate it in the chamber after being so and so. Otherwise, I would have dictated it now, at least the submissions. But I'll remember. I've written down everything. So I'll deliver it in the chamber.
Very
okay. So there are no matters, right? Bring everything there, huh? Mr. Courtmaster. Bring everything there. It's okay, I can do it. I can take it out from the.
Fuko, Vincent, Tushi. Court 1, Court 2, Court 2, Kodamushide. Fuko, Vincent.